All right, if we'd come to order. Good morning, Labor, Health and Social Services Committee. Welcome to your second meeting in beautiful Evanston, Wyoming. Today is June 22nd. Start with, we'll call the roll courtesy of Katie.
Good morning, Mr. Chairman. This is roll call for Thursday, June 22nd for the Joint Labor, Health and Social Services Committee. Senator Barlow.
He is here.
Senator Bouchard. Senator Dockstetter. Senator Hutchings. Representative Chadwick. Representative Clouston.
Here.
Representative Hornock.
Here.
Representative O'Hearn.
Here.
Representative Penn.
Here.
Representative Trujillo.
Here.
Representative Ward. Here. Representative Yin. Co-Chairman Baldwin. Chairman Zwanitzer. We have a quorum.
All right. With that, let me make sure there's no opening comments from anyone on the committee. Not seeing any. Senator Baldwin.
Just a real quick comment. Welcome to everybody that's here at Evanston. This is not officially in my district, but it's pretty darn close. I think Senator Schuler, whose district this is, will be stopping by later and we'll make her talk in front of the group. But welcome to Evanston. We appreciate having here. It's never this green. This is the greenest that's ever been. If you would have been here a month ago, it wouldn't have been green. It would have been white. But welcome to Evanston. Welcome to the area of Southwest Wyoming. Thanks for coming.
All right. With that, the first topic on our agenda is prior authorization, and we're running 8 minutes ahead. So let's keep that pace for the day. We have 2 bill drafts, and in the meantime, since we last met, I know we did have a working group meet courtesy of Representative Penn and Senator Dockstetter, as well as maybe 20 other stakeholders. And I don't know, Representative Penn joining us remotely, if you had any kind of opening comments or anything you wanted to kick off the conversation with from that working group meeting on how things are going.
Sure. Thank you. First of all, let me apologize for my voice. I have a cold today, so it's probably a good thing I'm not sitting there next to you. So yeah, we did get together and have the work group. I think that it went fairly well. We had quite a few people show up. We had a big group and got some things done. Thank you to Anna for drafting our legislation with pulling lots of things from different places. But I think it turned out how I was hoping, at least. I think there's a lot of good things. The points that we had discussed previously, I think are in here. And so again, not trying to delay things too much. Everybody's got the bill in front of them. Hopefully you've had a chance to read it. And I guess I'll just ask if any people have any specific points. We can go through the bill if that's helpful. I don't know what you prefer.
I'll probably have LSO walk through the bill. Let me check with Senator Dockstetter if he had any comments. Yeah. So we'll probably have LSO walk through the bill draft at this time. Anna, if you want to come up. This is going to be bill draft 24 LSO 68. Welcome, Ms. Johnson.
Good morning, Chairman, members of the committee. This is 24 LSO 68, prior authorization regulations. This bill draft creates prior authorization regulations. There's a staff comment on page 2 informing the committee that the Centers for Medicare and Medicaid Services is in the process of creating a new rule regarding prior authorization that will go into effect on January 1st, 2026. It's unclear at this time what that rule will entail. There are legislative findings that begin on the bottom of page 2 and a definition section that starts on the middle of page 3. There's also a staff comment on page 6 that indicates that there's already a definition of medical necessity in statute. And it's up to the committee's discretion whether or not they want to use the one that's already in statute or the one that's in this prior authorization bill draft. The created 2655-104 on page 9 requires health insurers to make any current prior authorization requirements and restrictions easily accessible on its website. They shall not implement new or amended prior authorization requirements unless their website is also updated to reflect the new requirements. And they must provide healthcare providers written notice of new requirements not less than 60 days before they're implemented. And then this new statute would also require that health insurers make statistics available regarding prior authorization, such as the medication or diagnostic test or procedure requested, reasons for adverse determinations, and whether these determinations were appealed. 2655-105 describes persons qualified to make adverse determinations. And then 2655-106 requires that health insurers inform healthcare providers if they're preparing to deny a prior authorization request and allow the healthcare provider to discuss medical necessity with the person responsible for determining authorization of the service. 2655-107 provides requirements applicable to persons reviewing adverse determination appeals. And then 2655-108 on page 15 requires health insurers to advise healthcare providers of an authorization or adverse determination within 5 business days of receiving the prior authorization request if the request is non-urgent. On page 16, if the prior authorization request is urgent, the health insurer shall notify the healthcare provider of the authorization or adverse determination not later than 72 hours after receiving all necessary information to complete the review. 2655-110 indicates that no prior authorization will be required for medications for opioid use disorder. And then 2655-111 on page 17 indicates that an authorization will be valid for 1 year from the date the healthcare provider receives authorization. A health insurer shall not revoke or limit a previously approved authorization if the healthcare services are provided within 45 business days from the date the healthcare provider received an authorization approval. And then the staff comment on page 18 indicates that some of the language in the model draft was deleted because it conflicted with other statutes in Title 26, Chapter 40. If a prior authorization is required for treatment of a chronic or long-term care condition, the authorization shall remain valid for 1 year. 2655-112 regards continuity of care for enrollees. If a person switches health insurers, a prior authorization for a medical service shall remain valid with the new insurer for 60 days. If the healthcare service is a covered benefit under the new health insurance plan. During that time period, the new health insurer may perform its own review to grant a new authorization. 2655-113, starting on page 21, regards provider exemptions from prior authorization requirements. A healthcare provider shall be granted an exemption from completing a prior authorization request if in the most recent 12-month period, the health insurer has authorized not less than 80% of the prior authorization requests submitted by the healthcare provider, and the healthcare provider has made a prior authorization request for that procedure not less than 5 times in the previous 12 months. The staff comment on page 21 indicates that the language "would have authorized" was removed from the draft because the phrase is vague and confusing. And then the staff comment on page 22 indicates that enrollees that there's a concern that enrollees may seek out doctors that they know are receiving exemptions for certain procedures so that they do not have to go through the prior authorization process. A health insurer may review whether a healthcare provider continues to qualify for the exemption once every 12 months. And a health insurer may revoke an exemption if it makes a determination that the healthcare provider would not have met the 80% approval threshold, provides the healthcare provider with the information it relied on to make the determination, and provides the healthcare provider with information on how to appeal the decision. The staff comment on page 26 indicates that there was a severability section in the model language, but I removed that from the bill draft because severability is already covered in statute. Pages 27 through 31 are conforming amendments. And then section 3 on page 32 is a repealer section. Section 4 indicates that the Department of Insurance has rulemaking authority. And then section 5 is a split effective date. And I would stand for any questions.
Questions from Ms. Johnson, Representative Chadwick.
Thank you, Mr. Chairman. You mentioned back on page 6, the conforming language. Besides the obvious, is there anything that LSO sees in the 2 versions that would be advantageous to one versus the other?
Ms. Johnson, go ahead.
Mr. Chairman, Representative Chadwick. I think I would leave that up to the discretion of the committee. But I mean, just be aware that there is already a fairly broad sweeping definition of medical necessity in statute. So I don't necessarily know that it's necessary to have a new one.
Further questions, Representative Chadwick? If not.
No, thank you.
Representative Ward?
Thank you, Mr. Chairman. Can you describe the repealer on page 32?
So that repealer was basic, the language that was removed had to do with it's there to separate payment of claims versus prior authorization. So there was some prior authorization language in Title 26, Chapter 40. And the only reason that I took out that language was to separate between the payment of claims section in Title 26 and then this new prior authorization language. So that this is just dealing with prior authorization, and Title 26, Chapter 40 was just dealing with payment of claims. But I can get you that. I can get you the language too, if you'd like.
Okay. Senator Hutchins.
Questions. Can you just give us a brief on what the prior authorization is all about for those who are joining us? And then on page 2, 2655-102, lines 26 to 28, a little concerned about that finding of the patient-physician relationship is paramount and should not be subject to third-party intrusion. I'm concerned about the third-party intrusion. We have a issue in our world today where there may be a need to have someone step in. Third party may not have anything to do with this, but if you can explain that after you kind of give a quick overview of the prior authorization, if you don't mind. Thank you.
Ms. Johnson, if you would.
Mr. Chairman, Senator Hutchings, there are concerns regarding prior authorization that it's taking too long for health insurers to tell healthcare providers whether or not a prior authorization request has been approved, and then there's also issues with adverse determination. And this bill draft basically just puts time periods and things like that into it would put those into statute so that non-urgent requests would be heard within 5 days, and urgent requests would be heard within 72 hours and things like that. It's basically just to streamline the process and make the prior authorization process easier and more efficient.
And then just a bit about findings. So as you're aware, we don't normally include legislative findings. There's not a lot here, but is that primarily because this is a semi-model act boilerplate language, or was this asked for, do you know?
Mr. Chair.
Yeah, Senator Hutchins?
Just so that what I asked is clear, it's page 2, lines 26 through 28. It was about the basically the third-party intrusions. It's kind of making a statement that we find that the patient-doctor relationship is paramount. Nobody should intrude on this third party, but there may be a need to do that. So that's why I was wondering how this sentence came about in the bill. Thank you, Mr. Chair.
You're welcome.
Mr. Chairman, Senator Hutchings, it was just part of the model language. That could definitely be taken out of the draft if the committee so chooses.
Thank you, ma'am.
Senator Dockstetter, question?
Thank you, Mr. Chairman. Mr. Chairman, staff, page 22, staff comment. I don't recall us being hung up on that situation where enrollees may be seeking out doctors that they know are receiving exemptions. I don't recall a lot of time spent on that and why that should be a concern, but we have a couple of key players in the audience that'll probably want to weigh in on that, they did most of the speaking in Casper, and they can weigh in on it during public comment. But the Representative Penn, do you recall the discussion on that?
I don't recall that either. When I read that, I thought, okay, maybe this came from somewhere else, but no.
Okay, thank you. Well, Mr. Chairman, maybe there's a quick follow-up when it comes time for public comment.
Sure, Ms. Johnson, if you know, and if not, we'll certainly ask the audience.
Mr. Chairman, Senator Dockstader, that came up during review of the bill. That was just a concern. That was an LSO concern
Oh,
that came up.
all right.
So
let's
it wasn't
proceed.
something you discussed.
Thank you, Chairman.
More times attorneys read bills, the more language we get added, right? Other questions, and Representative Hornock.
Thank you, Mr. Chairman. Just curious where this bill was modeled from. And then also, if based on that model, it has been enacted in some other place in some other state, how it's working. And, just kind of a little bit of history of that.
Ms. Johnson, if you know, I know we have some people who will follow up with you after that, but go ahead.
Mr. Chairman, Representative Hornock, this was based on the American Medical Association's draft language. I can get you that draft language if you'd like. And as far as how it's working in other states, I'm not entirely sure on that, but I'm sure there's people in the audience who could probably fill you in.
Okay. So committee, let me at least tell you where I think we're going and what I'd like to hear from the people online in the audience. Basically, the question is, I'm not sure the bill is ready, for us to certify it to go to the 2024 session yet. I guess I want to hear from people who are on the working group. If you think you need more meetings, where the areas of contention remain in the legislation, the 3 or 4 things that if this committee right now can help issue some guidance and steer you as a working group in a direction this committee overall would like to see. And then maybe any major issues we should be thinking about before our Saratoga meeting that we can go back and kind of talk to our constituents and agree this is, what our communities feel. So that's kind of where I'm trying to head the conversation. Representative Ward.
Thank you, Mr. Chairman. I just have one more question about that repealer. So I went and looked in Title 26 myself, and maybe you and I can do this offline, but it looks like 26-C does not exist. It stops at B.
Mr. Chairman and Representative Ward, there is an updated bill draft that corrects that. I'm sorry, but I'll get that. I'll get the correct statute
Okay.
to you.
Okay.
Yeah.
So I'm correct that the C does not exist?
You're right.
Okay.
That was a typo and then we fixed it, but I think we forgot to pass out a new version of the bill.
I think you sent an email that 2 days ago
Yeah.
with that with an update to just that, but you didn't update the whole notebook. Yeah. All right, with that committee and segueing, Representative Penn, do you have
Chair.
anything to add? Go ahead.
I do. Yeah, thank you. I'm sorry, I can't figure out how to raise my hand on my app, but anyway, so I did, as I was reading through, I did find a couple of things on page 4, line 17. I'm not sure if this is something we need to add in here or not, but it does say, so healthcare facility or provided by a licensed physician. Do we need to add language that, and I'm talking to Anna, do we need to add language that says licensed physician or licensed healthcare provider? I did notice that I think in the definitions, I think it was this bill. Now I've read so many bills at once, I can't remember exactly, but I guess open that up to the committee, licensed physician or licensed healthcare provider, since of course not all prior authorizations come through a physician.
Senator Baldwin, I believe that to be correct. Would you also believe that to be correct, Ms. Johnson?
Mr. Chairman, yes, and I could add that language.
Yeah, thank you. There's a couple spots throughout. I think page 5 has the same thing, but yeah, if you could go through and find those, that would be wonderful. And then let me just look through. Let's see, in the comment on page 6, it begins on page 6, talking about, so it says the committee may wish to consider using the definition of medical necessity under this statute, which is listed here. And I personally am okay with that if the committee agrees. However, on page 7, I don't love the inclusion of Roman numerals I or 1 and 2. I would just take those two out if we decided to include that definition, or I guess it could be, it would be linked in statute. Just because those Roman numerals 1 and 2, they are subject to change, and I'm not sure that that's the best. I don't know if that would require a repealer. I don't know if it's appropriate where it's at in statute. I haven't actually looked that up, but because those a lot of them are online databases and things, those are potentially subject to change. I don't know if there's any discussion on that.
Yeah, I think that's correct, and we'll, I think, listen to any other public comment, but as a final bill draft, I would be surprised if we include that language. Keeping Representative Penn's thoughts. Representative Klaus, you have a question for Ms. Johnson before we open the floor? Go ahead.
Thank you, Mr. Chair. Two quick questions. One, Representative Penn just spoke to. So when we're talking healthcare provider, would it be a healthcare provider in the same profession? So, you know, my question here is, are we having nurses review from a physician or a surgeon, right? Or is it surgeons in the same specialty? That'd be my first question. And then my second thing that we talked about originally was trying to streamline this process for everyone. Some states have a 2 or 3 page online form that all insurance companies go to. So we don't have to figure out which form for each company. Was that addressed in this bill?
Mr. Chairman, Representative Klauston. So on page 12 of the bill, this regards persons qualified to make adverse determinations. So people that are qualified to do that would have sufficient medical knowledge in a specific practice area or specialty. So the people making the adverse determination or the prior authorization would be required to have sufficient medical knowledge of that area for that particular service. Does that make sense?
Mr. Chair, it does. I just have a worry that I hear this complaint a lot where I'll have a orthopedic surgeon being reviewed by someone who's outside orthopedics type thing. So just want to make sure that that's clear, that because, you know, someone may have say a nurse reviewing a surgeon's work, and who determines if that person actually has the adequate knowledge?
Mr. Chairman, Representative Klauston, that is addressed in the bill, but maybe it could be tightened a little bit when you're discussing amendments and things like that. So,
Representative Penn?
Yeah, in our work group that was discussed. And I'm sure that when the insurance companies get up, they'll have something to say about that. The concern is the expense and being able to find the people to have an exact specialty match. And so I think during the work group, we'd kind of arrived at this, as long as they have sufficient knowledge of the subject area and the things that we've got in here. But that, yeah, the definite concern exists. I know the Wyoming Medical Society had that concern that, you know, their appeals are being reviewed by, or the adverse determinations are being done by people who may not even know the subject matter. And so I think we'll hear more about that with other testimony.
Okay. With that committee, I know Representative Hornock talked about where the legislation came, and I do believe we have the person from the AMA who helped write the model language, boilerplate language, Ms. Carroll, joining with us. Ms. Carroll, welcome to Wyoming's Labor, Health, and Social Services Committee. The floor is yours if you'd like to offer some comments on the bill draft we're working on, and where you think it could be helpful for Wyoming.
Wonderful. Thank you so much for having me. It's really an honor to be here. And as mentioned, I'm Emily Carroll. I'm an attorney in the American Medical Association State Advocacy Department. And I'm really just thrilled to be here to talk about prior authorization reform and thank this committee for undertaking efforts to streamline and sort of right-size this process that we feel at the AMA, and I know physicians across the country feel has really ballooned to an unsustainable size. First and foremost, it's the harm to the patients that drives our support for prior authorization reform. We conduct a survey every year that shows that nearly all physicians report care delays because of prior authorization or PA. that directly impacts patients' health. So 89% of physicians surveyed saw prior authorization that is having a negative effect on clinical outcomes, and 80% indicated treatment abandonment due to prior authorization. But I'd say most alarming and concerning is that 33% of physicians report that prior authorization has led to a serious adverse event for their patients, such as hospitalization, permanent impairment, even death. And numerous other studies sort of support those findings. There's also societal costs with the overuse of prior authorization. PA leads to increased resource use by preventing patients from receiving the right care at the right time. 64% of physicians report that PA has led to ineffective initial treatments, and 46 report immediate care or emergency room visits because of prior authorization. The harm to patients is the reason to reform this, but I'll also say that in Wyoming and physician offices across the country are finding themselves using insane amounts of staff time and resources submitting this paperwork just to justify to health plans medically necessary care for their patients. On average, physician practices complete 45 prior authorizations per physician per week. That adds up to about 2 business days each week dedicated to completing prior authorizations. And this is all taking place against the backdrop of a looming physician workforce shortage. 1 in every 5 physicians is planning to leave practice within the next 2 years. Physicians are burnt out, and I can tell you that administrative burdens like prior authorization play a major role in that burnout. So I'm thrilled to see your draft bill. I think it'll make a really big difference to patients. And I would suggest that related to some provisions, there's an opportunity to sort of make this reform effort even more meaningful. For example, we were really pleased to see inclusion of the publication of data and prior authorization statistics in there. You may hear from the health plans that prior authorization requirements are really limited to high-cost medications and procedures, but when we talk to physicians, that does not seem to be true anymore. We're seeing prior authorizations for generics or long-standing medications where there's no obvious or cheaper alternative. And to us, that's really not money or resources well spent. The publication of this data would really help us understand this better. And these data will also help patients choose plans that are right for them so they can see where barriers to care may exist. For existing, if they have a chronic condition, they need to make sure they can get their medications or services timely. This data will help them make informed decisions. Many other states have enacted all the transparency requirements actually in this bill. So despite what you may hear later, this transparency is doable and it's really needed. There were provisions in here that look at kind of ensuring continuity care and preventing care disruptions for patients, and we were really supportive of those provisions as well. Currently, you have a 60-day grace period when a patient starts a new plan to continue accessing ongoing medication as they transition. We would actually suggest extending that to 90 days to align with some new Medicare Advantage requirements that will take effect in January of 2024. And we think that 90-day grace period is really, really important for continuity of care. We also really appreciate you looking at decreasing response times in order to ensure that PAs are not delaying care. And we think it would actually be in the patient's best interest to shorten those timeframes further than what's in the existing draft. 24 hours for urgent care and 48 hours for non-urgent care is sort of the gold standard. And we've seen that enacted in other states. This will really help prevent the harm that results from delays in care. And these decisions really need to be made quicker. Also, there's a lot of good protections in here in this draft for patients with chronic conditions, especially those efforts to reduce sort of repeat prior authorization requirements for those who are stable on medication or services. We would suggest that maybe the language in here could be changed to allow a prior authorization for a patient with a chronic condition to be authorized for the length of treatment rather than just a year. You can sort of imagine a scenario where a patient with a chronic condition has multiple prescriptions or needed services, and they could find themselves having to return to the physician's office regularly for prior authorization renewals as each one expires sort of at a different time. Along these same lines, and as just discussed, we think it's really important, especially for specialists treating patients with chronic conditions, that the person making the adverse determination, that initial determination, be a clinical peer and of the same specialty as the physician or healthcare professional treating the patient's condition. So this is really important to reduce those delays in care at the onset. So there's some slightly stronger protections on the appeals process in this draft, but we think those protections should be implemented at the initial appeal or the initial determination to really protect those patients from those delays. And finally, we really welcome the provisions to reduce the overall volume in this bill of prior authorization. You've included a gold carding or exemption process for those physicians that have a high approval rate. It's really critical that as we look at ways to improve the prior authorization process, we're also looking at ways to sort of right size it and bring it back to its initial purpose, which was to target the outliers, to target really, really high cost drugs and services, and not the daily prior authorizations that are weighing down practices and are really harming patients. So we're excited to see those efforts to reduce the volume of prior authorization. So thank you for this opportunity. I'm really looking forward to working with you if possible, and of course our colleagues at the Wyoming Medical Society to enact these prior authorization reforms in Wyoming. So thank you. Happy to answer any questions.
Questions, Ms. Carroll? Senator Bouchard, go ahead.
Thank you, Mr. Chairman. Ma'am, I have a question about generic drugs. There's been in the past that has been an issue of contention. So does this bill fix that, or should we add language for that? And also, I don't know, did the federal was there a federal law enacted that said that if they deny a certain drug, that they have to provide a list of drugs that would take their place? And can we include that in there if they didn't pass that at the federal level? Thank you.
Ms. Carroll, if you know.
Absolutely. So no, I don't think as written, this draft would sort of remove prior authorizations necessarily for generics. There have been a few states that have enacted such provisions, and I think that would go a long way in reducing the overall volume. So happy to share, pull the language from other states that have enacted that and share that with the committee if that's something of interest. And I can't confirm for sure whether there's a federal law that does, as you say, but I think I can certainly look that up and get back to you. But I think even if there is, it's important for state laws to also take those steps. So.
Okay. Other questions, committee? Not seeing. Representative Hornott, go ahead.
Thank you, Mr. Chairman. You mentioned that several states have, or many states have enacted this. Can you give us some of those states just as an example? And also, again, how, I mean, I'm sure it's very subjective question, but how has it been working? Because is there a provision in here where if we narrow the time frame for prior authorization approvals, what prevents insurance agencies from just denying more within that time period? Thank you.
Ms. Carroll.
Yeah, absolutely. So as to the other states that have enacted similar laws, Kentucky, Illinois, Texas, and actually I can share we put together sort of a state law chart every year. I haven't updated it yet with the bills that have been enacted this session, but I'm happy to share that with you all so you can sort of see what states have enacted what provisions and sort of where Wyoming falls in relation to that, if that would be helpful.
Maybe for our next meeting in Saratoga, you could work with Sheila or whoever it may
Absolutely.
be to get that map, and that'd be great.
Absolutely. And I'm
Uh,
sorry, the second part of that question, and now I've forgotten, I'm sorry.
Oh, how's it working?
Oh,
What are
yeah, of
the,
course.
we're not the first state to do this, so is it, we can evolve if there's ways to make it be working better in Wyoming as we proceed. So anything pitfalls we should be looking for?
Yeah, no, it's a great question. I think it's working well in the states that have enacted it. I think, obviously there's always, we're working at the state and federal level to make sure that across all markets, there is prior authorization reform. But I think for the state regulated plans where this has been enacted and where it's live, it's working well. The sort of the trend recently has been to look at the growing volume. And I think this draft does that really well, because what we're hearing, and I think what we're hearing from patients too, is that the burden of prior authorization just seems to be ever increasing with no relief. So I really think some of the provisions in this bill are in line with what a lot of states have been enacting over the last couple of years that sort of try and reduce that burden and the associated harm. As to your point about whether the plans would just deny care if the turnaround times are too quick, I certainly would hope that wouldn't be the case. I mean, if care is medically necessary, it's medically necessary, and to deny just to get around timeframes, I would hope that our colleagues in the plans wouldn't be taking that measure just to avoid those timeframes. Those timeframes that I mentioned, the 24 hours for urgent and 48 hours for non-urgent, are certainly doable. We've seen it happen in other states. So they may sound short, but they're really doable. And when we're talking about medically necessary care for a patient, 48 hours is still a long time to wait if it's needed healthcare.
Any questions, Ms. Carroll? Not seeing you right now. Thank you for tuning in with us this morning. Certainly appreciated your comments. Have a great
Thank
rest of your Thursday.
Thank you. I appreciate
Committee,
it.
welcome. So committee, just so I kind of hit both ends of the spectrum, obviously healthcare costs money and somebody has to pay that. So I know we have several insurance companies and people on, who are actually doing the paying. I don't know if they've coordinated and have someone they wanted to go first. I know there's 4. Yeah, Representative Ward. Well, the insurance companies are thinking about who wants to come forward first and kind of maybe present the other side of why prior auths are good and necessary. Come on down, but Representative Ward, go ahead.
Thank you, Mr. Chairman. Would it be possible to have the people testify first before the agencies?
If there are people here who have thoughts on prior auth, I'm happy to anybody who wants to come up to the mic first. It could be a race. Anybody want to testify on prior authorization? I think about 9 of you are here for it. Just nobody wants to jump. Come on down, sir. Yeah. Welcome, Mr. Spencer. Please introduce yourself.
Good morning, Mr. Chairman, members of the committee. My name is Bruce Spencer. I am an attorney located in Helena, Montana. I am licensed in Wyoming and I represent the Mountain Health Co-op, which insures about 18,000 Wyomingites.
Thank you, Mr. Chairman. I am Dr. Ken Schecker. I am a physician, practicing physician, internal medicine by specialty. I am in Salt Lake City, and I'm also the medical director or chief medical officer for University of Utah Health Plans, which is the TPA for Mountain Health Cooperative, which is why I'm here today. And I might be a people, but I also work on the health plan side.
Welcome up to Evanston. Hopefully it wasn't that far of a drive for you as it was for Mr. Spencer. Any comments on how the working group's going and prior auth? And any where you think this committee should kind of weigh in today as negotiations and mechanics are working forward?
But happy to do that. I prepared something for that purpose before I came down. I was smart enough to fly to Salt Lake and drive over, so it wasn't quite the 10.5-hour drive I was envisioning. So, Mr. Chairman, members of the committee, the working group met was it May, I think? And frankly, we got a lot of work done in a very short period of time. We all worked very hard to come to some consensus on things we could come to consensus on, and there were some things we couldn't. And frankly, we ran out of time. And there are other issues that I would greatly appreciate the opportunity of working with providers and resolving. And I'm going to go through those very briefly for you, just so you understand where we have concerns. I think frankly, we can probably work out most of those concerns in another working group and then present you with a bill in Saratoga that frankly, we can all probably mostly agree on. You know, sometimes you have to agree to disagree, but you just have to see. So if I may, I'm just going to very quickly go through the bill and explain where we have concerns. And Dr. I keep forgetting how to pronounce it. Checker, if I may, on the technical portions, I would like him to weigh in so you understand why plans have a concern, not just that we have one, so you get some picture about that. We'll try to do this as quickly as possible. In terms of the legislative findings, and I agree with you as a lawyer. I think legislative findings should not be in statute. They just create problems. Frankly, it creates a veto opportunity, to be honest with you. But our plan finds them not to be, we don't believe those are accurate. And we don't believe there's any testimony or evidence that has shown that they're accurate. Those came straight from the model created by physicians. So I'll just leave that at that. On definitions, we have proposed some alternative definitions to providers. They're examining them and going to get back to us. So I am hopeful that we can agree on our definitions going forward and present that to the committee. I do want to comment just briefly on medical necessity. I think as a lawyer, it is vital that you do not have different definitions of the same term in your code. It creates all kinds of confusion. This is going to go into the insurance code. I strongly urge you to use the same definition of medical necessity that is already in your insurance code. That definition is not necessarily unique to Wyoming, and that's a good thing because these things occasionally get litigated and you have court decisions on the current language of medical necessity. You don't have any of that guidance if you don't follow the current language that's in the insurance code. And I don't believe there's been anything presented that says that's a bad definition. I would encourage for consistency, strongly encourage for consistency, that you stick with the definition that's in the insurance code. You heard some discussion about disclosure and review of prior authorizations, page 12, line 16. The current model says that insurance companies need to post certain information on their websites. I believe you recently heard from the AMA person that spoke that what they're looking for is, well, what types of procedures are subject to prior auth and how often are they subject to prior auth, right? So we can see, are you doing generic drugs? Are you doing? I'm not sure we're going to object to that. I have been working back and forth with providers to try and come up with either some agreed language on this or maybe an alternative solution, because I frankly think that the data will try to be used to say you can't justify the use of prior auth, and we want the legislature to prohibit it based on this data, right? And then I'm going to come back and say it's not statistically relevant data, and you've got errors, and we get into a big argument. I am trying to find an alternative solution to that. We're working through it. It's going to take some time. I'll be honest with you, but that's one of the areas we have some concerns. 2655-106 consultation prior to issuing an adverse determination. I think the doctor will have something to say about it, and I'll let him, because I want to keep going through. But that particular paragraph says that before a denial occurs, before the insurance company says we're not going to approve this with prior authorization, you have to have a peer-to-peer discussion between the insurance company representative and the physician or whoever's ordering the procedure. And that really causes some consternation and problems with the whole process. And if you can explain that.
Yes, thank you. The concept of having a conversation is a great concept. I think we should all have more conversations. However, the basis for doing prior authorization is scientific evidence. And scientific evidence is not necessarily up for debate. It's up for revision should additional scientific evidence refute things. But having a conversation, and in my role and capacity, I've been doing utilization management for 25 years. I was a medical director or the medical director at Select Health, which is Intermountain Healthcare's health plan for 20 years. And I've been with the University of Utah for 5 years, overseeing the process. At the University of Utah, I do all the peer-to-peers. I'm an internist. I have conversations with neurosurgeons. I have conversations with dermatologists. And they're all pretty congenial. And it's about the science. And there are times, I would say less than 20% of the time, if I have a conversation, will it alter the decision or the potential decision? Because the decision is based upon established evidence, which has been determined by specialists in that field. And who am I to then refute that evidence? The times that we change our position based upon the conversation is primarily around instances where we go, well, it's well established in orthopedics that a period of physical therapy may help alleviate the need for an invasive procedure. And I think we're all in favor of fewer invasive procedures if we can do that. So there are times that the documentation submitted just doesn't have it. We have that conversation, and I will tell you this happened yesterday. Oh yeah, I was talking to an orthopedist up at the University of Utah, and he said, "Oh, we did physical therapy. We didn't submit the documentation." I said, "Great." In that case, I was able to actually go to the record because I have access to the University of Utah records and find it. I was able to reverse the decision because we now had the evidence that we needed. But to otherwise have a conversation, the rule of thumb is if it's not documented, it didn't happen. If it's not in writing. And people will say what they will say on the phone. So we also have to withstand auditing. If I have a self-funded client or the state of Utah's Medicaid program, and they look at and they say, you must follow these rules to get reimbursed or to spend our money in their contract, and we don't provide that documentation that A, B, and C were there to approve it, we're then held liable also. So a conversation, as welcome as I enjoy the conversations, but they don't change the decision the vast majority of the time. The other problem then gets to be just getting a hold of people. Surgeons are in surgery. If I get a case request and then I go, well, it looks like it's going to be denial, I call the office. He could be on vacation. He could be in surgery. There could be a number of circumstances that cause it to then not be able to achieve that conversation in a timely fashion to then meet the timelines that we're required by this legislation to achieve. Somebody goes off for 2 weeks to Hawaii in January, and he submitted the request because he's not planning to do the surgery in the next 2 weeks. He's planning to do it in a month, and he does the request, but I have to get a hold of him within 5 days. So having it before, now I think having the right to a peer-to-peer is still important, but having it before a determination has been made doesn't achieve the goal. What I favor and what standard process is to do it after you've made a determination. You offer that, and we put that in our letters currently. If you wish to have a peer-to-peer conversation, we can have it. What I do in those circumstances is we have the conversation. If there's additional evidence, they present it. We do a reconsideration at that time. We don't even require them to do an appeal. And we'll look at it and say, okay, meets criteria now, great, thank you for the conversation. But to do it before a determination gets in the way of that timeline, and also, just creates a conundrum for saying, oh, you have to have reviews done. What it will do, to one of the committee members' comments, it will lead to an increase holding the line of just denying things. Because you've got to hit those timelines to be in compliance.
Thank you. I'll move on.
Senator Hutchins, question.
Oh, yeah.
Thank you, Mr.
Sorry.
Chairman. I believe we're talking about the paragraph on page 13, the top paragraph. I'm in the draft. I'm just want to make sure that I'm on the right page that you're on.
Yes, Senator.
Okay, thank you. Now, my question is, you're saying that the before the health insurer or contracted utilization review, blah, blah, blah. What I'm reading, it says they shall have the opportunity to discuss. So it's not saying they have to do it before, it's just if they want to do it, they can do it before. So maybe just a thought, can we put before or after the health insurer contracts, whatever? Would that make you feel better? Because it's just saying they have an opportunity. And then what you do in Utah and what's done in Montana, our physicians in Wyoming may want something different. So just, can you answer that?
Yes.
If that would help.
Go ahead, doctor.
I appreciate the question. I think the challenge gets to be, they don't know that it's going to be denied until it's denied. So they might have the opportunity to have that conversation, but that's now requiring an additional level of a notice. We have to reach out to them and say, hey, we're going to maybe deny this. So do you want to have a conversation? They can choose or not choose to do that, but that's adding administrative layering to the process versus just we've denied it. And as part of the notification, you can have a peer-to-peer if you want to talk about that denial. It doesn't replace the appeal process. It's in addition to the appeal process. And I try to emphasize that when I have these conversations. But I'm not sure how you preemptively do a conversation with someone who doesn't know what you're going to determine until it's determined, without potentially causing issues and additional complexity to the process.
Yep, follow up, Senator Hutchins.
Thank you, Mr. Chair. Mr. Shepherd, I believe.
Checker. Checker. It's
Oh,
like
what?
checkers with the S in the front.
Like the burger, right?
Yes.
My question is, you're saying it's gonna add complexity to the situation. What if the physician has something to say that may help with that decision, so it isn't adverse? So again, I'm just seeing that this is just saying you have an opportunity to speak to them. You don't have to speak to them. We're not making that something you shall do, but you can do.
And I appreciate that. I understand that. It's just, how do you tell somebody and give them the opportunity to decide if they want to do something without reaching out and contacting them? You're almost guaranteeing that you're going to do a preemptive peer-to-peer, because we're going to call the office and say, yeah, we're thinking we're going to, deny this request. Well, you're going to get the office staff. That provider may be there and he may right at that moment say, oh, I want to have a conversation. But one, he doesn't have the case in front of him. He's not prepared to have the conversation. He has to research things himself. Or, oh, yeah, Dr. Smith just left for a 2-week vacation. And so the timeliness is the factor in doing it preemptively. If you do it post determination, it allows for a timely and allows them, it takes us out of the first timeline. The timeline for an appeal is different because it doesn't start clicking until they file it. So that's their choice. So that's a window that they can have that conversation. And it doesn't have to be that day. It could be another day. It is a time that would allow them to prepare the information that might be necessary to do a reconsideration then. I will tell you that the reconsiderations that we do, we turn them around within 24 to 48 hours. And that's partially because of our process that we're just adding to the case. We're not having to refile and redo documents. So hopefully that answers your question. Not trying to evade it, but I do see issues.
Everything costs time and money. And we're trying to get care quickly. So, yep, Mr. Spencer.
Mr. Chair, members of the committee, just on this paragraph on page 12, 2026-55-106. There is a shall on page 13, line 3. It says the healthcare provider shall have the opportunity to discuss medical necessity prior to the determination. As a lawyer, I would read that as mandatory. And frankly, if it didn't occur, I see an avenue for patients or providers to cause some legal concern, right? The other thing that maybe it's an unintended consequence of this paragraph, but I do believe it could certainly cause insurers to miss the deadlines, the 5 business days and the 72 hours that are contained in this bill. So it has an unintended consequence.
Does it really vary from current practice, though? I mean, right now, we don't have it in statute, but the way things operate, is that current practice, or is this really outside of the current bounds, in your opinion?
So, Mr. Chairman and members of the committee, I do believe it's outside current practice.
Yeah.
We do not have a pre-denial conference. That's what this is requiring. Before we're making our decision, we're going to have the conference. So that doesn't occur. It's not in the matrix of how to comply right now, certainly for Mountain Health Co-op and the University of Utah.
For our multiple health plans that and states, University of Utah Health Plans is in 5 states. Nobody does the pre.
So, go ahead, keep going.
All right, let me go as fast as I can through what we're at.
It's really the kind of issue areas that you want
Yep.
the working group and us
That's
to kind of be
exactly-
on our radar.
Yep, that's exactly what I'm doing, or I'm gonna try to do. So the period of prior authorization, period that it's effective, Mountain Health Co-op and Dr. Schecker has some concerns about the 1-year length, and maybe he can briefly explain his concern on that.
Yeah.
Please do.
And thank you again. The 1-year duration is, I certainly can understand the logic of let's do it for a year. Well, one, is that a calendar year or a fiscal year? Some health plans are on a fiscal year, some are on a calendar year.
Do you know,
I'll
page
have
you're
to
on?
find that. I'm sorry, I forgot to note that in my notes.
17, we believe.
17.
Our apologies.
At 17, line 6.
So the challenge with the year time period is though, it is such a long period of time. The circumstances with regards to the plan requirements could change. If the determination is, let's say, made in December, but the plan language changes January because they've renewed the contract, but the sponsor of the contract, the group, has decided that they're going to exclude something, or they're going to, now we have this conflict when it goes for a year's time period that may overlap a calendar year where the contract changes. It also, scientific evidence changes. And what was perhaps the standard of care in March may no longer be the standard of care in December. And we do have requirements to review our policies that we are using to make determinations on a minimum an annual basis. And I will tell you that we do much more frequently than that based upon evolving evidence, because we want to provide services that have been proven to be medically necessary. I think, I certainly, many health plans may have a 2-month authorization window. Is that too short? Perhaps. I think a year is too long. 6 months could be in my experience, 6 months is a reasonable time frame, on the outer edge of the reasonable time frame, and it avoids some of the problems that you run into with calendar year plan changes and other documents. So I think the 1-year time frame it's one of those things that we need to talk through to try to figure out what is the right that meets the needs of reducing administrative burden from having to resubmit an authorization. Also, we have to keep in mind that things change for patients within a year.
But you think 6 months might be generally more?
It could be, but I think that's one of those points to talk about. I know others might feel like 90 days, but you have to find that right balance between administrative burden of having to resubmit these and the evolution of what could occur with a patient and such. So somewhere between 90 and 180 days makes more sense to me.
Representative Ward.
Thank you, Mr. Chairman. Dr. Shecker, your comment about that the science could change. I think that's addressed in line 14, 15, and 16. It says provided that the authorization period is consistent with evidence-based guidelines. So I think that addresses your concern there. Also, can you tell me how often you provide authorization and then revoke it in less than a year?
Well,
If you know.
our current authorization periods are much shorter than a year now. So I don't know that I can answer that question to say how many times if they have to resubmit the authorization. The reality is anybody who delays an authorized therapy for a year, you would wonder why they're doing that. If it's medically necessary now, it may be medically necessary a year later, but did their clinical circumstances change so that you would wonder if this procedure is still the right procedure and they still need to get a different authorization.
Yep, follow up.
Thank you, Mr. Chairman. Dr. Shecker, how often do you provide an authorization and then revoke it, period?
Rarely.
If you know.
It's a very uncommon occurrence because typically if it's approved, there's an intent to move forward. I don't know that it revokes, but more expires. I don't recall in recent memory at all revoking. There are prior authorizations that expire for not performing the service.
Representative Ward.
Thank you, Mr. Chairman. How long is the authorization currently good for then?
Well,
Is it
our
2 months?
health plan is currently on a 60-day authorization period. During COVID, we extended that to 120 days. My personal feeling is just knowing sometimes with the delays of physicians and busy practices and people's lives, we see a lot of individuals who do elective, and we're talking about elective procedures. We're not talking about emergent or urgent procedures because those don't require authorization. An emergency procedure gets done and gets paid for. But, elective, whether it's hysterectomy, we can see those being requested. And then the woman says, well, I want to get through graduation season, or, I've got some time off. It's in December. I don't want to do it during the holidays. Can we put it off to January? They also ran into the problem. It's the end of the plan year. Can I do it sooner than January? So we do see sometimes elective delays but again, we've not had a problem with that. And if there is a delay, we certainly haven't heard a lot of noise around complaints of, I have to submit this again, because it's really just taking the same file and resubmitting. And that authorization process, if it's got approved the first time, it's a quick reapproval.
One more.
Thank you, Mr. Chairman. Dr. Shecker, since you brought up COVID, did you pay for ivermectin during COVID?
We
Shecker.
prior to COVID, ivermectin was was a drug that was covered because it has medical indications for treatment of lice and such. So after that, once we started to see a surge in ordering ivermectin, given the evidence for around it, the science around it, we implemented a prior authorization to review to make sure it was done for its FDA approved indications, so that it was being done for medically necessary reasons and not for covered for circumstances that we felt the evidence was insufficient to determine benefit and could possibly cause harm for patients.
All right. Sorry, Mr. Spencer, if you could wrap it up a little bit. I know it's
Not a problem. So in that particular, that same paragraph, page 17, line 14 to 16, we would prefer to add language FDA approved dosing and duration to authorization period is consistent with FDA approved dosing and duration or evidence-based guidelines, and Dr. Menendez Harper can further explain that if necessary. Another definitional concern is on page 4, line 4, the definition of chronic condition. We suggested to the working group that they use the Center for Disease Control of chronic definition, and I thought this was agreed on, but I could be wrong. But the Center for Disease Control definition is conditions that last 1 year or more and require ongoing medical attention or limit activities of daily living, or both, not 3 months. And it just a 3-month period and the definition of chronic, I don't know that those mesh. So we are concerned about that. And the 2655-113, I'm just going to say this involves a procedure, what we refer to as gold carding. So it's like pre-approval of a physician, they don't have to go through prior authorization. Payers are not necessarily on board with this concept at this time. And we have concerns about it. And we certainly can answer.
when you say payers, you just you mean
Insurance companies.
companies?
Sure.
Payers is a cool new trendy word.
You
Okay,
don't
got
like
it.
that? Yeah. Finally, I do have a concern about the amendment that you see on page 27, line 12 in 2640-201. Wyoming currently has existing law and regulations that allow a patient to appeal an adverse prior authorization decision. Okay. This bill, the new language in the bill and the AMA model, doesn't address appeals other than to say what the qualifications should be for the person looking at the appeal. Okay, the AMA model and the new language in this bill does not provide a patient an appeal right. Okay, it's not in that bill. The amendment appears to be removing patient appeal rights from existing Wyoming law. And I have some concerns about that. I don't think that would be the intent of the committee, and it's certainly not the health plan intent to remove existing law that applies and grants appeal rights. So I would just urge, before we amend existing insurance code, to look extremely carefully at why we're amending it. And that's one that I had some concerns about. That summarizes the concerns that I have. I don't know if Dr. Shecker has additional
Dr. Shecker,
comments?
additional comments?
Yeah, I had a couple, and thank you for the opportunity. So one of the areas that I think, again, I believe that health plans, insurers need to have some oversight to this process. I think putting up bumpers that everybody has the same set of rules makes sense. We just need to make sure that they make sense for everybody. As noted originally, the language of this in the legislative findings points to the fact that this was a document crafted with a specific intent. I will tell you that prior authorization does not exist as a cost containment process. It exists is cost containment part of it? Certainly. Health insurers hold the fiduciary responsibility. We are given other people's money. And we are asked to make sure it is spent wisely, just like the legislature is asked to do that for the people of Wyoming. Now, we do prior auth and there is cost implications, but we do it to help protect the people. Because there are providers who will provide services that may not necessarily have cost or, that have cost to them, but they may not have huge side effects, but they have potential. People die from tonsillectomies. Not to say that we're prior authing tonsillectomies, but people do die from hip replacements. And there is a lot of subjectivity. Medicine is a business, and it's a business for the providers as much as it is for the insurers, as much as it is for the organizations that sponsor insurance. So taking that in mind, we are trying to do a process that helps to protect patients from potential harm, not only physical harm from having the procedure done, but financial harm. Many health plans have high deductible plans. Some of you may have high deductible plans. When people go in to see their physicians, they're assuming good intent, but that physician could have a bias or that other provider. And so that's one of the things, again, speaking to how the legislative intent of this needs to perhaps be rescoped a little bit. I also would like to speak to specific parts of the bill, however. And one of those is the reporting piece. I think there's work that needs to be done there because some of the reporting piece does not necessarily make sense from an actuality of how prior auths are done. It talks about the specialty. Well, we have a list of different specialists. A person might call themselves a varicose vein specialist, but there may not be a varicose vein specialist listed. So what do you call them? Well, there are family practice docs that are varicose vein specialists. There are general surgeons. There are vascular surgeons. So how do we report that? And does it matter? Aren't you really interested in if somebody wants varicose vein surgery, how many of those did we approve or deny? Does it matter what the physician was that requested it or the nurse practitioner? And I think, around appeals in some, which is another area of reporting, though I can understand wanting to understand what happens when things go to appeals. There is a delay. Typically after a determination, an office has up to 180 days to do an appeal. Can you imagine how you're trying to track statistics on something that they might choose not to do until day 179? How does that make the statistics that you're reporting reliable? So my concern centers around some of the areas of reporting don't create actionable information. And if it's not actionable, why are we doing a report on it? So I think that's an area for discussion. I wouldn't throw out reporting altogether, but I think I would generalize it a little bit more and perhaps take the specifics out of the legislation. We've already talked about the timelines, and I would want to say one last thing I would like to say. I would like to thank Representative Penn and Senator Dockstader for the session that I was involved with a couple months ago. It's clear from the document that's here that they listened to some of the perspectives that were provided and are trying to find a language that is middle of the ground, middle of the of things so that it works for everyone. So with that, that's all my comments.
All right. Thank you much. And I'm sure Ms. Howard and Ms. Johnson are taking copious notes as part of this process to make sure we end up at the right spot. Senator Dockstader, question?
Thank you, Mr. Chairman. Are you willing to share? You went down a list, each of you. Can you share that in written form to Representative Penn and myself?
Mr. Chairman, Senator, yes, let me clean it up a bit. Those were sort of my internal notes, but I will get it in written form and get it to all the committee members about the things that we feel we could work with providers with and come to agreement on maybe for your next committee meeting. Yes.
Thank you. We appreciate it. One more follow-up, Mr. Chairman.
Yep.
You spoke optimistically of our meeting in Lander that walked out. Maybe agreeing, I'm not sure that I made my 12 hours of windshield time feeling good about the whole thing. We still have a situation where we're not providing enough follow-up care without all the confusion of waiting and delays. So I would hope as we continue to work with this gentleman, you're both very professional, knowledgeable, very impressed with what you understand and know about all of this. I would hope you'd have an understanding that we want to protect the money. It's other people's money. We want to protect that. But we also want to get to a point where people are not waiting for good health care, where my providers are not waiting for a return on their funding as well. But more important, while we're elected to take care of the money too, we're elected to take care of the people. And I would hope that we'd find a solution there with that, gentlemen. Appreciate it. Thank you.
I
You
agree,
bet.
Senator. Thank you.
Yeah, Mr. Chairman, Senator, absolutely. And as part of the process with working with the providers, trying to come to agreed language, we're learning things. That's part of they're learning a little bit from us. We're learning a bit from them. And hopefully the solution helps solve some of the problems you mentioned.
Thanks for taking up some time. Other key, I guess I didn't. Well, Blue Cross is on their way up. Welcome, Miss Roday. I think you're going to be joined today. Brought some backup. Welcome. Is it get situated?
Good morning, Mr. Chairman, members of the committee. My name is Heather Roday and I represent Blue Cross Blue Shield of Wyoming. I'm joined today by Raymond Red Jr. and Chris Urbanek. So we're happy to be here with you today. So Blue Cross Blue Shield is a not-for-profit insurance company, and we're the only insurer domiciled in Wyoming. We're pleased to have served Wyoming residents for over 75 years. We have 9 Wyoming offices, and our employers, leadership, and board members are Wyoming residents, and therefore we care very much about Wyoming issues impacting over 125,000 Wyoming members. It's important to remember that we don't use prior authorizations as mechanisms not to pay for care. There are reasons to have prior authorizations. There was a question earlier about why would we do this? They ensure the appropriate use of limited resources. So for example, preventing insurance payment for cosmetic surgery, which might not be medically necessary. They protect members from having to pay for care that isn't evidence-based and safe. They prevent expensive care from being given when less expensive, as effective, or more effective care could work for them. And they assure providers will be paid for their work, especially when that work is complicated and expensive. While we believe in the benefits of prior authorizations, we also acknowledge that there's room for improvement and reform. Therefore, we are pleased to have been included in the work group discussions, which helped frame this bill draft. We appreciate Representative Penn and Senator Dockstedter's help with the following changes that were included in the draft language. So a change in the definition of standard and urgent timelines, which narrows the timelines currently allowed, but remains workable within our complex systems. The work group understood insurer requirements when posting medical policies and made accommodations for those challenges. The work group heard our concerns about standard forms and removed them from the draft. One standard form wouldn't allow for all the complexities involved in complicated treatment. And given limited personnel in Wyoming, we also very much appreciate the elimination of the specialty match and the Wyoming license requirements. While we believe these are good requirements, we would echo the sentiments of the previous speakers by saying that the topic of prior authorization is very complex, and this bill dropped pretty late for review. We believe that the bill as written needs more time to resolve the following issues. So we would agree that the inclusion of findings isn't needed in the legislation and would suggest that they be removed. Some of the definitions need to be finessed, and we support the staff comment about medical necessity. The suggested language that was discussed earlier, B1 and 2, needs to remain in the definition because peer-reviewed literature allows medicine to change. And this reference is flexible enough to capture those changes over time. We use these references when we develop our medical policy and allows that medical policy to advance over time. If consultation prior to issuing an adverse determination is required, we would also suggest that that may lengthen the turnaround times. And there was a question about whether this is or is not a requirement. On page 12, line 22, it does say that insurers shall notify the provider. We also
Real quick,
agree.
Sorry, do you do that now? I mean, is that not standard practice? Not to take you off the train, but yeah. And do you know if that's standard practice kind of informally at this point? Mr. O'Brien, welcome.
Chairman Swanitzer, thank you for the question. So I think the difference here is a distinction between, if we read how it's written, if a health insurer or contracted utilization review entity is preparing to deny or considering rejecting the medical necessity of a healthcare service, the health insurer or contracted utilization review entity shall notify the enrollee's healthcare provider that medical necessity is being questioned. So that's a little different. I think so. The way we approach it today is we will provide notification of the denial to the provider, to the member, to any additional parties involved. We do that through a variety of mechanisms, electronic fax, letters, et cetera, make sure that everybody gets notified. This implies sort of a step before that. So we are questioning this, we are going to deny. It's sort of a preliminary notification. I think that's the distinction we're trying to draw here from what occurs today.
So, and how many cases now do you, we'll just call it a check-in with for more information instead of we'll call it a pre-denial? I mean, this is just asking, I think, for another step before, the company gets a, hey, it's a denial. We don't really understand why, forcing a step of, we'll call it a check-in, or we're thinking about it, any other information you want to provide. How often does that happen now where you're thinking about denying, but you just, before you make everybody do more paperwork, if you deny and they appeal, you reach out in a friendly manner and say, can you give us some more information? This is kind of hazy. We don't understand it. Does that happen?
Chairman Swanitzer, I would tell you that that happens from time to time. I couldn't give you statistics. I know that our pharmacy department in particular spends a fair amount of time reaching out to providers and saying, we didn't receive enough information to approve this medication. Can you provide us this additional information so that we don't have to make a denial? On the medical side, I believe we do that occasionally as well, but I couldn't speak to the exact.
Fine. It does kind of happen, but the semantics here, I understand, are a little concerning. Sorry, Mr. O'Day, go ahead.
Thank you, Mr. Chairman. Other items of concern that we would like to have further conversations on, we would again echo the discussion about the reporting requirements haven't been very well defined. And without standard reporting formats, we would also agree that that the amount of information and the quality of the information garnered from such reports may be questionable. So the definition would be helpful. Gold carding wasn't discussed during the work group session very much, and this bill contains language which we are concerned may create some loopholes with unanticipated consequences. So we would like some more time to work those through. We agree with the previous speaker's question about the changes that were made to the existing statute. So we would look forward to some clarity there. We also agree with adding in the FDA approval for that year timeline on page 17 because the FDA approval is important and we rely on that. And you'll probably hear more about that later. And we also haven't seen the changes that were discussed earlier for the repealer language. And so we would like to learn more about that. So therefore, we agree that much progress has been made through the efforts of the work group and LSO. We believe this bill still needs some more work before we can support it. We suggest another work group as it has been mentioned earlier. And this additional time would be helpful to finalize remaining items under consideration. And we would look to do so by the September meeting to be able to bring something forward for your consideration. We thank you for including us in this complex conversation, and we look forward to bringing this across the finish line at the next meeting. We stand for any questions.
So at least where I'm coming from, that was perfect. You gave us a list of the 8 issues and you're committed to work and try to get us something.
Thank you, Mr. Chairman. That's correct.
Thank you. Questions for Blue Cross Blue Shield of Wyoming? Not seeing any. Mr. Red, welcome. Anything you wanted to add on since you're sitting up here?
Thank you, Chairman Zwonitzer. I think the only thing that I would echo that Heather had already mentioned is the repealer language and some of the amendments that have been made to existing statute. If I look at it in section 2 on page 27, it looks like they refer to the same statute, which is 2640-102. And I think what they meant to refer to was 2640-201. And you see here that they've made amendments to 2640-201. And we feel like those are somewhat problematic, as Bruce had mentioned from Mountain Health Co-op. But in addition to that, the repealer language, I think, is also referring to 2640-201. And in that language, it's saying it's going to repeal sections that are actually just redlined or striked here, not actually repealed, but just have been amended. So I think I'm just highlighting that there's some issues with the amendments that are being made to existing statutes and the repealers that are being proposed. I just think there's some confusion there, and I haven't had a chance to think it through. But going up to the definition section as well, when we're talking about medical necessity, those statutes and definitions are highly complex. And when we start to kind of mess with those, just in the context of prior authorization, it could create a pretty big mess. And there's also regulations from the insurance department on medical necessity as well. So those could be impacting those regulations as we're changing the statutes. So that's about it. Thank you.
Thank you. Smith, thank you very much for being here. Ms. Mendez Harper, you're on the line and asked to go. Welcome. Good to see you remotely. Floor's yours.
Good morning. Thank you so much for the opportunity to speak today. And I do have to apologize. I was on my way to the airport yesterday to join you in Evanston and hit a threshold of being ill enough that I did not want to spread that to anyone there in that room. So I'm keeping that illness here in my little bubble. So anyhow, my name is Dr. Lugina Mendez Harper, and I'm a pharmacist. I work with Prime Therapeutics, which is a pharmacy benefit manager. We're owned by 19 Blue Cross Blue Shield plans across the United States, including Blue Cross Blue Shield of Wyoming. I wanted to just touch briefly on and say thank you for the working group opportunity. I'm really encouraged by the progress that was made between the draft that you viewed in April and now this draft. And my comments are going to be limited to the legislation that's being proposed from the perspective of prescription drugs. So a couple of things that I just want to point out. Overall, when we do a survey of healthcare plans and commercial plans, the vast majority, 83% of commercial enrollees are in plans where less than 10% of drugs are subject to prior authorization. So I share that information just so that we have a clear understanding of it's not the vast majority of drugs. And it generally is limited to instances where we're worried about quality of care, affordability, and safety. And so what I wanted to do was share, there's a couple of concerns that I have from a prescription drug perspective with the draft legislation. And I just want to approach it from the perspective of quality of care and safety. So the first concern that we have that's actually pretty important is in section 2655.11. So page 17, line 13 says that we provide a prior auth for 1 year, and that shall be effective regardless of any change in dosage. So again, that's specific to prescription medications. And I just want to share an example. What we would like to have, we understand the intent. The intent is, to have some flexibility when dosage changes are made, that they don't have to go through the process again. Totally understand that. But I think what we would be asking for is some common sense guardrails, and would like to have something in there that says if dosage changes are made consistent with FDA labeling and approved dosing, that makes sense. And so let me just give a couple of examples of where the devil's in the details. So we use prior authorization quite a bit to help us with the opioid crisis when it first began, and we still use it now. But the way this is written is if we as an insurer provide authorization for oxycodone 5 milligrams, which is immediate release, it's used short term, it's used for pain management. The way this is written, that same person who has a prior auth for, say, oxycodone 5, the doctor could shift to OxyContin 80 milligrams. It's the same active ingredient, but that's a sustained release product. We know that once you get above a certain threshold of OxyContin, that the risk goes up for adverse effects. So again, it's not that we want those common sense guardrails in there to make sure that it's still legitimately consistent with good medical practice. Another example that I have with that is kind of more recently what we've been struggling with is all the TikTok doctors and celebrities out there that are talking about drugs like Ozempic and Wegovy and Mounjaro, which are used for diabetes, but helps with weight loss. Right now, it's approved for once a week dosing, once a week injections. And the way this is written is if we got a prescription for twice weekly dosing, which makes no sense, that's not how it's approved, we would have to continue to cover that process. And so again, those are just two examples of some instances where we understand the intent, but we want to make sure that there's some safety guardrails, because that's really the basis of the prior authorization programs that we have in place. So there's only one other section that I wanted to touch on, and that's section 2655-113. The first one is on page 22. And I'm sorry, I'm looking at I'll put it right here in front of me. I was really encouraged that the LSO and the stakeholder working group, that we were able to say, not only do we want a percentage when we're looking at the concept of gold carding, but should there be a threshold of the number of submissions of prior auths? And so there is some language added in there. On line 6, it says 5 prior authorization submissions. And I would just ask for additional the opportunity to discuss that further. While that might make sense for a medical procedure, that threshold seems really quite low for prescription drugs. So just, again, want to explore that further. And then finally, the last concern, also in that same section, page 25, line 2, this is where it's talking about the external appeal process. And elsewhere in the legislation, there was a really nice job done of saying, the healthcare practitioner that's reviewing these prior auths has to have expertise in the area, has to have qualifications. And we got away from that, same specialty language. And that was of concern for us because as pharmacists, we're the drug experts, but we're not specialized like I'm an endocrinology pharmacist or I'm a cardiology pharmacist. We're generalists, but we have that entire, expertise for medications. So my ask here would just be that we remain consistent and use the language that's on page 12, which just says, that the healthcare provider has some expertise and has the ability to make these determinations. So again, I want to thank you for the opportunity to speak. This has been a great example of how working groups can come together, really, roll up our sleeves and make some progress. And we've done some really nice work and would make the same request that we have the opportunity to continue that work and just kind of iron out these final last details. So thank you for your time.
Thank you. Questions from Ms. Mendez Harper. Senator Bouchard.
Thank you, Mr. Chairman. I want to address the scary monsters you mentioned on opioids. The scenario that you suggested, I think, isn't that already covered under our opioid laws? And I mean, why would a doctor if he did try to game the system on the insurance side, he would be picked up on the other side, which have strict prescribing laws on those type of drugs. And second, on Ozempic, are there people trying to do 2 doses? And if I look at the prescription guideline, it does say once a week on the same day. So I think that's an easy call. I don't think whether we pass this bill or keep things the same, that those are already standard. So I don't see that being a scary monster. And quite frankly, a lot of the things that I see stemming the problems that are occurring is our state statute does not have a similar necessity clause as CMS, as in the federal guidelines. I think that our code is what's caused some of this mess. So I'll leave it at that, but I would like to follow up on those 2 scary monsters.
Ms. Mendez Harper, do you have any thoughts on that? Go ahead.
Yes, sir. Yes, sir, Chairman Swanitzer and Representative. I thank you for that question. I think, and again, I think it's in the devil's in the details. If you look at page 17, line 13, it says that we have to have a valid prior auth for 1 year. And it shall be effective regardless of any change in dosage. That's very broad. And so what we're asking for, again, we understand the intent, but what we would want is just something very simple that says dosage changes that are consistent with FDA approved dosing and duration. Again, the goal here is to have the ability to take action and do things when there's a safety concern. And these are 2 examples of where that would occur. And there's many others, but I just thought that those were, whether it's opioids, which is a huge problem that we still struggle with every day, or this newer thing that's happening because of, TikTok and celebrities talking about weight loss medications. These are 2 areas where, we just want, again, just some common sense guardrails that we're able to fall back on to say, like, no, you can't do that. That's not, or help us understand why you're wanting to do that. There may be a reason, and that's fine. But the way this is written now, it says that person can go from oxycodone 5 to 80, and that's where we are. So, I thank you for the question.
Okay, other follow-up, Senator Bouchard?
Thank you, Mr. Chairman. Yeah, I'd like to follow up. I looked at a case where Blue Cross actually approved medication, and then they came back and denied it. And there was a long process in trying to fix the problem. And it was a medication that was used off label. And what it did was it was to correct a kidney condition that they tried to give them steroids, which was approved, but the steroids caused such adverse effects that they moved to another drug that was off label. It's amazing what this patient had to go through to get Blue Cross to finally come back and give a year authorization. And I think that's what we're trying to fix here. Because that's the problem is we can say, hey, that's off label. We can have 100 reasons why not to approve that drug. And yet in the end, that's what it took to take care of the patient. So I've got these cases that I can share with the committee. But I think that's the problem here. We're trying to generalize this into simplicity, and it's just not simple. Sometimes these healthcare situations need further care than can be given by the normal textbook answer. So, I've got cases, like I said, of Blue Cross denying and then coming back finally after they fought it. And here's, I think, the crux of it is people give up. They get tired of fighting. I think we're trying to get to a solution here. And I think we've got to dig in and do a little better job of not letting people like this case I'm talking about slip through the cracks. So that's where I'm at. So anything to add to that?
I don't know if there's a question, Ms. Mendez Harper, but feel free if you want to jump in. That's why we're pushing a bill. Go ahead.
So, Chairman Swanitzer and Senator Bouchard, thank you for the question, for the comments. I would say, just to reiterate, I think in general, the insurers in the room are not opposing development of prior authorization legislation, but just asking for some common sense parameters. So I agree that, you know, I think that we are all on the same page that we need to come together and try to come up with a solution specific for Wyoming.
Other people here to testify, Department of Insurance, Department of Health, Department of Insurance, you came all this way, come on down. Welcome, Ms. Howard, Ms. Rinking. Always good to see you. Thoughts on this piece of legislation, where we should go with it?
Yes, Mr. Chairman, members of the committee, my name is Tana Howard. I'm the Deputy Insurance Commissioner. With me today is our Senior Health Policy Analyst, Jill Reinking. Yeah, so a lot of my comments, I'll be brief. We've worked with LSO and Ms. Johnson on this draft a little bit, and we're thankful to be included. A couple of the things that might help a little bit with some of the insurers too, and their comments is the purpose of what we really want to kind of zone in is that prior auth is, and this bill draft is before, right? So we currently have legislation, or we have, right, statutes in Chapter 40 for medical necessity, which is the after piece. So we just want to make sure that this piece is going to be the before piece, which is kind of the reason for some of the comments for some of the repeal, which probably does need some work with the appeal process and things like that. And we're happy to work with LSO, but that was the kind of reason behind some of that repeal, is to make sure there was no conflict in the statute, that because currently there are some provisions in Chapter 40 where if you needed a emergent, you know, anything, IRO or a review before a procedure or whatnot, it's in there. This is way more comprehensive, obviously, with the prior authorization, and that's great. But that was our reason for the repeal, to just keep those two pieces separate, one before and one after Chapter 40 being payment of claims. So consumers still have the opportunity to, if for some reason a procedure was not approved, to go through that independent review process and have those opportunities for appeals. We also would like to comment on the medical necessity definition, as LSO and several others commented. We would encourage the same medical necessity definition that we currently have in Chapter 40. We feel like it's comprehensive and consistent. Also, any insurer, because we're a prior approval state for forms, so any insurer that references medical necessity in their policy right now, we make sure that they have that definition. If we have two definitions, that could not only be confusing to insurers, but really to consumers. So we just want to make sure that that consumer protection piece is in there. But we do feel we're happy that we didn't have to go first, because there was a lot of discussion, and I think we're on a good path, and we're happy to continue working with all of the stakeholders, as well as LSO on these issues. One of the other options or comments that was made in terms of removing some of the appeal language in 4201, I would agree with industry and their comments that it probably does remove some of that appeal process. So we may need to add, or I mean, of course, it might be a consumer protection to add some of the appeal language in the prior authorization. Obviously, that's up to the committee, but yes, that would remove that appeal process on the front end for prior authorization. They would still have it on the back end if a procedure wasn't paid for, but it would remove that on the front end. So, and with that, we'll stand for any questions.
Questions for the Department of Insurance? Say, Representative Warnock.
Thank you, Mr. Chairman. I'm curious if you know, if there's anything in state statute now that does set parameters on the time period for prior authorization approval, or is that one of the intents that this bill takes care of that's not currently in state statute?
Ms. Howard, no.
Yeah, Mr. Chairman, Representative Warnock. Currently, in chapter 40 and in our regulations, chapter 63, there are provisions for any denial that's really related to medical necessity. So as long as an insurer denies something for the reasons of medical necessity, the appeal process would apply. And there are, so that could apply for prior authorization beforehand. There's not as much in terms of the timelines of when they have to, respond to providers, or it's more communication towards the consumer, what the insurer's responsibility is to the consumer to make sure they know that they have appeals process to try to get their procedure approved or paid for. But it's kind of all encompassing. It's just medical necessities in general. That's how we interpret the law right now. If this were to pass, then obviously there's a lot more in here, and there's a lot more provider communication and between insurers and providers. But there is law currently within chapter 40 and 63 that deal with any type of medical necessity denial. So there's provisions in terms of if there is something that needs to be approved for an urgent life-threatening procedure, there's those 72 hours provisions. Then they have a certain amount of days to provide the appeal notice and for the insurer to communicate to the consumer when they need to get, and the consumer works with their physician to get those prior authorizations or claims, depending on what it is, a denial for medical necessity rectified or approved if possible.
Okay, follow up, you're good. Representative Hornak, follow up.
Yeah, thanks. So there's been discussion about narrowing those time periods. What prevents a insurance agent from then just denying more claims, to start with, so that you have to go through that appeals process? Does that happen other places? Is that a concern?
If you know.
Mr. Chairman, Representative Hornak, I don't know specifically. I'm not sure I 100% understand your question. I mean, in terms of, what gets denied is all based off of the contract between an insured and an insurer. The provisions of what is covered on that policy is all terms of the insurance contract. So whether or not, and then each insurer has that medical policy for each covered benefit of what a provider and what a consumer needs to complete to meet medical necessity and to have a procedure or treatment approved or a drug for that example. But those are terms of the insurance contract itself. And in terms of, the legislation here, there's nothing in our code right now that says, hey, you have to pay this or you have to provide this, because those are private contracts and up to those insureds of what type of policy. Insurance isn't one size fits all. I say it all the time, and I'll say it today to make it consistent, but those are the terms of the policy. I hope that helps.
No further questions. Thank you much.
Thank you.
Department of Health or Medicaid or anybody else? Go ahead, Mr. Bully, Ms. Bush. You look like you're coming up together anytime that the doctors and the hospitals are getting along. It's a good day. Welcome, whoever, you probably couldn't even sit next to each other. I like it. Whoever wants to go first. Welcome, Ms. Bush.
Good morning, Mr. Chairman, members of the committee. Sheila Bush with the Wyoming Medical Society. We too want to offer our appreciation for the working group and being included in that. It was a long day, but it was a really good day. And Representative Penn and Senator Dockstader did an outstanding job of listening to the concerns. I think the bill you have in front of you addresses a lot of those and does it really well. I want to start by just kind of bringing us back to what the healthcare landscape really looks like a little. Much of this morning has been down a few rabbit holes, and I'd like to just pull us out of those for a minute. In the kindergarten view, which I'm pretty good at, you have insurance, which exists in a contract with a patient and the insurance company, and they mitigate risk financially. So a patient enters into an agreement with an insurance company with an expectation and understanding that if they pay their premium, the coverage that they may need at some point will be covered. And there are nuances to those contracts, but that is essentially the role of insurance. It is that mitigating risk for patients, the same similarly that we do for car insurance or anything else. The physicians and other providers in the system exist as the providers of that care. They're the ones who seek out the schooling and the education and expertise to deliver the best care to those patients, whatever need presents. And then you have your licensing entities and your hospital facilities, credentialing committees, those kinds of things. They really function as the policing entity for safe medicine. So if a provider is doing something unsafe, which has been discussed kind of at length this morning, we have a myriad of laws already in place and all kinds of mechanisms designed to address that. And so it feels like much of the conversation this morning has been the resistance to reform prior authorization, because insurance companies have aggressively moved into the role of policing safe medical practice. And that isn't an appropriate mechanism or utilization of insurance. That's not their role. We have other entities and other systems in place to perform that role, and they do it well. And so all this conversation about it's our job and we have to do all of these we're 2 hours into this hearing almost, talking about all the ways insurance companies can police and oversee and supervise medical practice. And that really is not appropriate. And so from baseline, we sort of resist that philosophical position that seems to have been presented pretty consistently this morning. So with that, I will just offer that we're in support of the bill. We do believe there are sections of the bill that can be tweaked. We prefer the tighter timelines, 24 hours for urgent, 48 hours for non-urgent. Other states are doing it. It's not an impossible task. And we feel really strongly about the transparency and the data. I think if we're going to continue to have meaningful policy conversations and do our due diligence, both as the public and as lawmakers, you have to have all of the information. And a group of entities coming forward and saying, we just can't possibly provide you that data, I think begs a larger question about what's really happening in prior authorization if it's so impossible to tell us what the data looks like. There was a concern raised about how could we possibly disclose the specialty of physicians. I think a really easy answer is whatever that physician is boarded in or how they're licensed with the State Board of Medicine is a pretty fair way to indicate their specialty. I think it's important for a variety of reasons, but one of them could be you have procedures that might be denied within primary care and authorized within specialty care. I think those are interesting. So, for example, mole removal often has a different process for prior authorization. If a primary care physician is seeking to do the procedure versus if a dermatologist or a specialist is seeking to do the same procedure. I think those are interesting. I think that's data that matters. And I think it's worth all of us having access to what that looks like from that perspective. The final thing that I would add, and then give it to my colleague here, is it seems as though a lot of the prior authorization system is set up to put people into the appeals process. And we have some staggering data that shows if you look at the appeals data, 80% and I'll get the exact number for you here in a second, are overturned. And so the more that the delays in care can happen on the prior authorization end, often appeals aren't completed or they're not pursued. It's a very burdensome process. And so it serves as a very effective way to deny care and delay care. And that hurts patients and that hurts our care system in a state that's already pretty fragile with our hospitals and providers. I think layering on some of these burdens unnecessarily that have not been proven to improve patient care or patient safety need to be addressed.
Can I ask you a quick kind of out there question?
Yeah.
Do you, as a society, represent all physicians and doctors? Does that include, do you have any members who are physicians who are employed by insurance companies and do the work on the other side of the table? Are they still dues paying members of your organization? And is that, I mean, how how's that working? I guess if you do have them, are you discussing and are they adding to your conversation of how to present this?
Mr. Chairman, great question. I'm trying, my face will tell you that I'm struggling with how to answer. So the Medical Society represents physicians and PAs, the really important PAs. And we represent just a little over 50% of Wyoming's actively practicing workforce in medicine, or physicians and PAs. We do represent a lot of our physicians who are employed by insurance companies. They are active members and continue to be. We have not sought out their specific opinion on prior authorization, but we also have not heard any sort of complaint from them about the society's role in this conversation. Does that answer your question?
Well, I just want to apologize because I'm pretty sure all the insurance companies in the back of the room started going, oh, we might have our doctors reach out to the Medical Society now. So
Yeah, you're welcome to.
Which all conversation is good. But yeah, I just wanted to check because it did seem interesting as many physicians are working not on the other side of the table, but in, you know, the insurance world of insuring, making sure they're also your members.
Yeah, absolutely.
Okay. Mr. Bully, go ahead.
Thank you, Mr. Chairman, committee members, Eric Boley with Wyoming Hospital Association. And I too want to echo the sentiment, grateful for the working group and especially for Senator Dockstader, Representative Penn. I think we made great progress. One thing I would tell you is that we're pretty careful in the interim topics that we bring forward, and we try to be really thoughtful. This is a really important issue, as you can tell, not only for the providers, but specifically for the patients. And it's getting a lot of national attention. There's a finding in here that talks about the feds are going to do something by 2026, I believe. Just before our last meeting, I had just returned from the American Hospital Association meeting in Washington, D.C. Statistics showed just with Medicare Advantage plans, Cigna is the TPA that oversees that. They were denying 80% of the prior authorizations and then had a super high overturn rate once those were appealed. So why do we need this? We've heard from the insurance companies that this isn't done for cost containment. That's an absolute fallacy. It is done for cost containment in many cases. The other thing that we've talked about today, we've asked questions about data. There is no data. You ask the insurance companies how many you've denied, how many you've overturned. You can't get that information. So I think this bill is very, very important for us to realize the scope and breadth of the problem. I don't think we're caught up in a lot of the definitions. I think that there are some tweaks that can be made to this, and I think another working group, if we need that, to hammer out the final details. But we're really pleased with where you are right now. We like the language, and I think that we are seeing some successes in other states. On the data piece alone, we presented this at the last meeting. Washington just passed legislation that requires reporting and data, and I think it's super important. I also think that streamlining the process, getting these done, and having those authorizations in place for a period of time to treat the patients is vital. There's so much time that is spent on this, and we've talked about that. But what happens is if it falls on the patient, many, many times the patient just gives up. And in the long run, the providers don't get paid, is basically what happens. We can't really afford that. Luckily, we have specialists in our hospitals that can help work through that. In the physician's office, they have people, but it just adds to the burden of getting paid for services that are rendered. I heard a conversation today that there might be physicians or providers that abuse the long-term authorization and that they would continue to provide care that's not necessary. That's not what providers do. I think that's one of the rabbit holes that I heard about. We have hospitals and providers that are trying to provide the very best care and take care of patients in the state. And I think that we're a long ways down a good road here and getting some good legislation passed. And we're favorable. We support this wholeheartedly, but we're also willing to work on any compromises that we need to do to make this even better legislation. With that, I'd answer any questions. Thank you.
Senator Hutchins.
Thank you, Mr. Chairman. Thank you for your testimony. I'm tending to agree with you, which is awesome. Page 13, where they had the concern over enrollees, healthcare provider being able to have an opportunity to discuss the medical necessity. Where did that come from? And is that important to you guys?
Ms. Bush?
Mr. Chairman, Senator Hutchings, it is important to us. I think it starts on page 12, if I'm making sure that we're talking about the same area. This is prior conversations to an adverse determination. Is that correct?
Yes.
So this is really important to us. I think it's the opportunity for a physician to be alerted to the fact that something might be denied based on medical necessity, and it gives that provider who's closest to the case and the patient the opportunity to have a conversation with a peer, a clinical peer, which is a critical piece of this, to talk about the medical necessity and make their case and maybe give some more context and reasoning behind what might also be at play prior to the denial being rendered.
Thank you.
Yeah.
Mr. Chair,
Yep.
follow up if you would. On page 17, where they had the concern, pages 10 through 16 on the length of the authorization. Just on page 10 alone, or line 10, where it says each authorization shall be valid for 1 year. Can the words at least 1 year be put in and kind of make this whole, or do you feel as well that more work needs to be done on this particular area where they were concerned?
Go ahead.
Mr. Chairman, Senator Hutchings, we believe the 1 year is good. We all favor, I think what you intend to maybe get to with the at least 1 year would be the duration of the treatment. And that really is a preferable avenue, I think, in terms of if a patient, if a provider and a patient have gone through the prior authorization process for a diagnosis, then the prior authorization should extend through the treatment of that condition. And so whether it's 1 year or if it's the duration of treatment, I think we're comfortable with both, but we're not comfortable with reducing that beneath a year.
Gotcha. Thank you.
Yep, Mr. Billy.
Mr. Chairman, Senator Hutchins, also on that same section, we heard from the PBM that they're worried about changes in dosages. Again, that's patient-doctor relationship, and dosages sometimes have to be adjusted. It doesn't change the course of treating that illness or that what needs to be done. So I just think that it's not a valid concern.
Thank you, sir. I see that all the time, Mr. Chair, if you don't mind, with dosages I get. It's like, this is too strong. Oh, it needs to be a little, let's switch it. So thank you. Appreciate that.
Mr. Chairman,
Mr.
Chairman,
Bowe.
Senator, a good example is my wife takes thyroid medicine and they adjust the dosages all the time based on what's going on. I mean, it's a simple explanation, but it's the same for many illnesses. So thank you.
Senator Doxter, you have a question?
Thank you, Mr. Chairman. I respect my chairman's comments, and when they opened up the meeting saying, one of them saying, the one conducting, saying, I'm not sure we're ready for prime time with this. I appreciate that. We're kind of here and there, but the two of you also worked very, very hard on this. Do you see a way to abbreviate down from 34 pages and get something done now? I have, it keeps me up at night when you tell me that our friends at the federal level are going to correct this in 26. I think this is a Wyoming situation. We've seen other states take it upon themselves to do the correction. Do we need 34 pages to correct it?
Thoughts? Go ahead.
Mr. Chairman, Senator Doxter, as far as I'm concerned, we're ready to roll. I'm fine with the bill and the language it's in right now.
Okay, Senator Bouchard.
Thank you, Mr. Chairman. I just want to make a public statement that Mr. Bully, I agree with you.
Okay.
Another unicorn today, Mr. Chairman.
All right. With that, thank you both very much for being here. Ms. Herman, you'd like to talk about prior auth? Go ahead, Marguerite.
Okay. Thank you, Mr. Chairman. I've been editing my comments all morning in light of what everyone has said, and so I'll try to be brief. Marguerite Herman here, and I'm speaking as a consumer representative for the National Association of Insurance Commissioners. And the consumer reps, this is on their radar in a sort of urgent way right now. I will say that pre-authorization is considered part of that thing called utilization management that includes also claims, denials, and appeals. So after the fact as well. And so some of the concerns that I may mention are at some point, it would be kind of nice to apply it to all denials, whether pre-authorized or after the fact. I'll join the chorus of people congratulating the working group for coming up with this bill draft, which to the extent that it ensures a system, a process that is transparent, fair, reduces inefficiencies for unnecessary review or redundancy that does not add value. And that's kind of the point is, I guess, where the rubber hits the road is what adds a value and what simply is delays. And as we all know, to borrow from another sector of the world, treatment delayed is treatment denied in a lot of cases. And to the extent this bill, and as it goes through the work and gets refined further, achieves that, that's wonderful. And just real briefly, I would just sort of emphasize making sure consumers are given this information. There are occasions in the bill that tosses in the enrollee as kind of an afterthought to the provider. I would try to make the consumer an equal party to both the application or the request for pre-authorization, the notice of changes of those requirements, and equal partner in the appeals as they go through that. So I guess that would be and also I would add that if they are included in those noticing requirements, that it be done in a language that a consumer would understand. So not because, as we all know, insurance language can be pretty turgid. So and medical language highly specialized. So they ought to be equal partners and also to understand the notices and participate in the appeals. As far as the notice goes, I didn't miss something, but it sounded like if there's a change in the and I appreciate the comment from the Department of Insurance that insurance policies are contract between the insured and the insurer. And so any changes in that should be noticed. And I consider pre-authorization as part of that agreement. It should be noticed more diligently than simply a notice on a website. Outreach to the person who's buying the policy, again, in terms that person can understand, and maybe with a place where they can get things clarified if things are not clear. Then I appreciate making sure pre-authorization review is quick, clearly explained, medically justified, free of unproductive redundancy, and which puts, I think, obligations on both the insurer and the provider. It's not just borne by one side of that. And once again, with all this, the process being notifying the consumer and involving the consumer in the process. I appreciate the creating an expedited timetable for emergency. I would suggest that maybe there's room in there for avoiding pre-authorization. There's a provision for treatment of substance use, and I would say cancer and mental health treatment maybe have some provision where even 24 hours can be a delay can be catastrophic to a patient. So maybe there could be a category of where pre-authorization is waived completely. Limiting, and I appreciate limiting, as this bill does, when and how an insurer can change its mind. And I want to just finally just really endorse what has been said in favor of gathering data. And I guess, data on denials, actually both pre-authorization. It'd be interesting to also get them on all insurance claims. But the basics for denials and the outcome appeals, and then And I guess that data should be reported to the Department of Insurance, compile that report to the legislature, but also just make public what insurance companies are doing and their record on handling pre-authorizations. And I guess further than that, beyond that, what you do with the data, it's worth gathering anyway. And then beyond that, perhaps a plan of how to put that data to work. But that clearly I think is important. And I'm not here to demonize insurers or providers, just sort of to speak up for the consumer, what will help consumers participate in their own coverage, which they're paying for, and to make sure they get the services they have contracted for. Thank you.
All right. Thank you, Ms. Herman, NAIC Consumer Rep. Not seeing any questions. Appreciate it. Committee, with that, let's close public comment. In my mind, I think there's some more work to be done, at least from some of the concerns on maybe the repealer language and making sure statutory citations are correct. I know some of you said you were ready to go now. Let me check with Senator Dockstader and Representative Penn. I think we're more than happy to have another working group meeting. If you would like maybe everyone to issue comments, I think there were 5 or 6 issue areas. If they all, worked with you, if you want to have a public meeting, if you want them to solicit comments, and you and Representative Penn can kind of work with the groups and LSO and get back to us. What's the path forward you'd like to take? Senator Dockstader.
Thank you, Mr. Chairman, and let Representative Penn speak to this, but would like a summary, as I asked our colleagues from Utah and Montana to provide theirs in kind of a nutshell form. And those from the insurance industry that spoke, I sense our hospitals and medical society are comfortable where we're at. We may try to find some in there. As far as public, Casper was public. This is about as public as it gets with cameras and everything else. We'll try to squeeze one in. That it's tough to do these, but I'm wondering if we can just put it together based on those comments. If I get with Representative Penn, or if Representative Penn would feel more comfortable getting back together as a group. If we get together, I'm happy to make that public too. We can announce our location. Representative Penn, your thoughts?
Yeah.
I hope you heard all that, Representative Penn. Go ahead.
I did. Thanks, Chairman Zwanitzer. So I agree with that. I mean, if we can, given what we accomplished before, and we did have a lot of discussion just now with a lot of good suggestions, I think that if we can get those suggestions and kind of consolidate them, and then possibly Senator Dockstader and I can just get together and kind of with LSO kind of hash things out, and then hopefully come next meeting with what we come up with and have further discussion at that time.
Follow up?
Yep, go ahead, Senator Dockstader.
Mr. Chairman, what if would LSO with our staff be willing to conference in on a phone if I went over to Representative Penn's country in Lander and we kind of get this sorted out? We announce our time and location should anybody else want to be there, but nonetheless, get this more consolidated and get something that might be more acceptable to our chairs. And I would also ask that our chairs, if they have something specific in there, that they both give us a note as well on that. Thoughts?
Go ahead, Anna. You can make anything work. I'm guessing is what you're going to say, but thoughts?
I'd be able to do that. Just give me a date and time.
I think from my perspective, if we don't go with another, 4 or 5 or 6 hour meeting that you all had and focus on those 5 issue areas, as long as you do it soon enough to get a draft out to everybody, because I'm certain they'll all have comments and there may be 3 or 4 then amendment language changes. We could consider it Saratoga and push something forward. I mean, I think we're all hopefully on this side of the table agreed we need something, whether that's current state, putting in statute or moving the ball a little down the field is probably where the arguments are. But at least from my standpoint, whatever we can do, get out there quick enough so everybody can comment. Representative Hornak, thoughts?
Thank you, Mr. Chairman. Just a point of discussion for the group. Before that meeting happens, I'd like to kind of know the leaning of this body. We've heard a couple of things. So in the current draft bill, there's the time period, the 5 days for non-urgent on page 15, I believe, and then following that, page 16, the 72-hour for the urgent care requirements. And we have heard that in other places, it does work to do a 48-hour for non-urgent and a 24-hour for urgent. That shortens that time period quite a bit. But I think, you know, for me personally, I would think that when we're talking about patient care, let's get it done. The patient may be suffering and they may need something quickly. It seems like it would be worth the discussion to talk about the possibility of shortening those time periods to the 48 and the 24 hours that we've heard. I'm just curious if that would be something that this body would, you know, I'd like to open that discussion up just on that point before this bill moves forward, to see if we want to change that and use that in what moves forward. Thank you.
Mr. Chairman,
Comments?
if we could.
We can just
when
drop
make
poll
those
too.
comments, just keep it tight, please. Don't, I mean, I don't want to get it spread out into a whole new thing, and I share with you those concerns. That's why in my comments, well, we have a concern for the money. We also have a concern for the people too, so. But if there is feedback and what we emphasize, keep it tight, please.
We can just go real quick. I can do a straw poll. So let's say your options are what, 24, 40, 24 emergency, 48 non-emergency, or 48 96, or a longer timeline. So that work? If I just ask for a show of hands from everybody, kind of where you are, everybody who thinks, you know, other states do it and Wyoming can do a 24-hour emergency, 48-hour non-emergency review, raise your hand. 1, 2, 3, 4, 5, 6. That seems pretty. Representative Penn. Everybody who thinks maybe 4896 for Wyoming is probably more appropriate. Maybe I'm the only one, but I think sometimes things take a couple days and then longer. Up to 5 days now. Well, that gives you a pretty good sense of room of in Representative Penn and Senator Dockstetter where we are on that issue. Any other issues somebody wants? Kind of a brief straw poll about kind of move in. Representative Clouston, we'll go to Representative Ward. Go ahead.
Thank you, Mr. Chairman. You know, the last speaker brought up some things that could be exempt from prior authorization. And I would like to hear from all the insurers as well as the hospitals and the medical association. Are there things that you think that we could exempt from prior authorizations? You know, especially guys, you know, from Utah, are there things that you just exempt? And maybe that could save all of us some time and some money.
Real quick, Senator Dockstetter, do you want me to have everyone email comments to LSO, or do you or Representative Penn personally
Let's do.
go to Ms. Johnson and
LSO 's
she
not gonna
compile?
LSO is not gonna like this, but we funnel it through them. They have a great way of making things concise for us. And if we could do that, and then we'll set up a time, Representative Penn, I would suggest a public setting, should people want to attend a town, a county, or a hospital boardroom or something that's a public setting there. Okay.
So you think it's fair to ask in the next 2 weeks for everybody to issue thoughts on where they'd like the legislation to go and perhaps language they'd like to see to LSO, to Ms. Johnson, and then we can compile kind of everybody's viewpoint, give it to Representative Penn, Senator Dockstetter, and then if you need to kind of have a working draft, have a meeting or a Zoom meeting that everybody can kind of air their thoughts and get us something workable about a month before Saratoga. Does that seem like a plan? Representative Penn, that okay?
Representative Penn?
Yeah, that
Okay.
sounds good.
Audience members, anybody have grave concerns with that approach? Okay, because I know we're just rehashing a little bit of the old stuff, the same issues that we're going to at Saratoga. Representative Ward.
Thank you, Mr. Chairman. A question on the process.
Mhm.
So what precludes us from moving this as it is and then just adding amendments?
Not a darn thing. So if someone wants to make a motion for this to be a committee bill at our second meeting for 2024, they could certainly do that.
I so
Um,
move.
And at that point, you might have some more amendments that could just come in January, February, and we could work on it there. So if that's the motion at the time to move the current bill draft in front of you to the 2024 budget session, seconded by Senator Bouchard. Any discussion on that motion, committee?
As the
Senator
discussion,
Dockstetter.
Mr. Chairman, then we would take this and work from that at our next meetings, Representative Penn and I. Am I understanding what we're doing here?
Well, if this motion passes, we wouldn't have necessarily any further work in Saratoga on it, but there could be, you know, an amendment drafted to be introduced in February that was kind of not a substitute bill, but a further elucidation of the points. So it just depends if you think we need more time and work on it for our Saratoga meeting, or if you're ready to vote on it now and just think there will be some minor amendments in February. It's really up to the committee that says, does this need a lot more work or a couple of minor twitches? I'm probably in the point that it needs a little more work than moving it, but if other people are there, we'll entertain the motion. Other discussion? Senator Hutchins.
Mr. Chairman, what does the Senator Dockstader, how does he feel about this?
That's an interesting discussion. Senator Dockstader, how do you feel?
Thank you. I'm not opposed to moving it as is, but I heard some concerns that we need to address and get in there. I don't know if having the work session gets that done or putting this through and then we have to come back and do a follow-up. Either way, we can still get the piece of legislation passed. I would like to see it more consolidated. It's a lot of things in here that are all over the place.
Senator Baldwin.
Yeah, thank you, Mr. Co-Chair. I'm swayed here that we need to have that working group at least have an hour or two, get back together with all the points that have been raised, all the points that will be raised, sent to them by email. And my reason is this, is I think if we do it the other way, we move the motion ahead, do a vote on it today, pass it, then when we come in February, we may be looking at a very long committee meeting, whichever committee I would prefer House that it goes to. And in a short session, that may be a big deal. I would prefer that it come forth to that working group, tighten it up in September. We actually have a more concise bill, as a good senator next to me says, and vote on something a little more concise, a little bit more accurate, that brings it all together.
Mr. Chairman,
Go ahead, Senator Dockstader.
I support that. We are tasked with getting a good piece of legislation into the session, and that's what we're trying to do here. And remember, it's a budget session, and I'd like to make sure that what we put there is more acceptable.
Okay, Senator Barlow online, thoughts?
Thank you, Mr. Chairman. So I appreciate the opportunity just to weigh in. So if I know we had to have prepared amendments at this meeting, I would have had numerous amendments to this bill draft. So facing a 2/3 introductory vote in a budget session, I can assure you if this is a legislation that goes forward, I would vote against introduction just because I do not believe that we would have the time and the right people at the table to actually do the work. So I support not moving forward with this bill draft as a sponsored bill draft, but allowing the working group to come back to the committee and the committee to continue its work at our subsequent meeting. Thank you, Mr. Chairman.
All right, let's have a vote on the motion. All those in favor of making this a committee bill at this point to 2024, please say aye. All those opposed say no. Okay, that motion has failed and reflected online as well. So we'll be talking about it in Saratoga. Any other discussion on the path forward we currently have? With that, Senator Dockstader, Representative Penn, we wish you the best on compiling comments, and I think you've heard the concerns and thoughts of this committee. Senator Barlow, anything to add? I can't tell if your hand's still up. Go ahead.
Thank you, Mr. Chairman. So just to clarify, if members have comments, I know they're going to work with the working group, but if members have comments, we are also able to submit them through ANA or through LSO, so they are at least on the radar of the working group. Is that accurate?
I believe so. If any member of the committee, just issue your thoughts and comments to Anna as well to compile, let's say by the 10th of July. That seemed like a Tuesday. That's a Monday morning. Yeah, by Monday the 10th. Okay. With that committee, we're only running a little bit behind. Let's move on. We're probably not going to take a break. So if you need a break, just as long as I keep a quorum up here, we're going to go back to LSO draft 30, reimbursement of health insurance overpayments. Ms. Adams is presenting this. I'm optimistic this one's going to go quick without as much testimony, but Katie, welcome, and thoughts on this piece of legislation.
Thank you, Chairman Zwanitzer. Members of the committee, my name is Katie Adams, LSO.
This bill is health insurance reimbursement of overpayments. And this bill creates a new statute within the insurance code to specify a time limit for insurers and other specified individuals to seek reimbursement of any overpayment of a health insurance claim to a healthcare provider pursuant to a health insurance contract. The time limit specified in the bill is 2 years after the date the claim was paid, but the 2-year time limit does not apply if the claim was fraudulent. There is a lengthy staff comment that addresses 4 key issues. So first, there does not appear to be a Wyoming statute specifically setting forth the look back period for these types of claims. The current 10-year time limit that was mentioned at the April meeting likely stems from the general statute of limitations for contract claims. So this bill is modeled after a Kentucky statute that had a simple statute of limitations that seemed like it might be a good working starting point. Related to that, look back statutes in other states are often complex. The staff comment highlights some of the key features of those statutes. And then finally, at the April meeting, the committee asked whether pharmacy benefit managers would be covered by the amendment. As explained in the staff comment, there appears to be a separate 2-year look back period that applies to pharmacy benefit managers. Section 2 specifies that the act applies to overpayments that were made on or after the effective date. And then section 3 specifies that the act would be effective July 1st, 2024. And with that, I would stand for any questions.
Questions for Katie? Seeing none. Thank you much. Any major public comment on this piece of legislation? Is everybody fine with 2 years? Mr. Boley, you need to come up. Okay. If you have grave concerns with the 2 years, come on down. Otherwise, I'm just optimistic. For now, this is where we should be. Welcome, Hospital Association.
Thank you, Mr. Chairman, committee members. I don't have any problem with the 2 years. I think it's great. I am curious if we could add an amendment here, and I think it's germane to the bill. Our hospitals and our providers have a hard time getting their fee schedules from the insurance companies. So I don't know how they can even calculate or know whether or not they're receiving overpayments or underpayments. I'm wondering if we could amend this to require insurance companies to provide fee schedules to hospitals annually and upon request, so that we can make sure that they're being paid in accordance with the fee schedule. Thank you.
Any questions on that? I'm kind of tangentially falls under the subject matter. Questions for the Hospital Association on that request? Not seeing any at this time, Mr. Boley. Thank you. Anyone else wish to publicly comment on the 2-year payment window? Mr. Hackman, are you jumping on this one? Go ahead.
Good morning, Mr. Chairman and members of the committee. Hollis Hackman with the Wyoming Psychological Association. I'm their legislative chair, and I'm a psychologist from Sheridan. We applaud the efforts of LSO to put this bill together. We've had members approaching us with concerns about requests from insurance companies for repayments from over 3 years ago. We had one just here a week ago that went back that far. Now that really puts our providers in a difficult situation, and it's hard on the folks that are seeking treatment from our providers. So we applaud this effort. My only comment would be, and I'm getting this from my membership, if it could be shorter than 2 years, that would be great. Our providers have about a 12-month window to work with a situation. And if it goes beyond 12 months and there's been some kind of denial from the primary insurance provider, there's no opportunity to try to submit a bill for a secondary provider because that window's already closed. So anyway, this is a great move forward. We appreciate this effort, and I think those are all my comments, Mr. Chairman. I would stand for any questions.
Questions for Dr. Hackman? Seeing none. Thanks. Any other public comment? If it went to 1 year, we do have more comment. Welcome back. Floor is yours, Ms. Howard.
Thank you. Thank you, Mr. Chairman. Tana Howard, Deputy Insurance Commissioner,
Jill Reinking, Senior Health Policy Analyst. We're neutral on the bill. The one comment we did want to make is in relation to the LSO staff comment related to pharmacy benefit managers. When we reviewed this bill, we did think that there could be a conflict within the 2652-103. The PBMs are allowed to have that 2-year look back period within the audits. And then there is additional timeframes for the communication after the audit and going back and forth through the pharmacy with the pharmacy, and that could exceed the 2-year look back period or payment. So it could be interpreted, and maybe we're interpreting it wrong, that, you know, if the 2-year period, if a PBM audited a pharmacy and then found something where there was overpayment or whatnot, if it was past that 2-year mark, could it be a conflict in the statute with this?
Do you want an amendment, Ms. Howard? I understand that there's an interpretation issue, but I don't know how to solve that unless you want me to do a weird carve out.
Yeah, it's just something we wanted to bring to the committee's attention. Jill, do you have what's your opinion on an amendment?
Sure. Do you guys have a new PBM policy person hired yet?
It is currently listed, so we can publicly say if anybody is interested. It is.
They can apply.
They can apply. Yes.
Ms. Reinking, anything else? If you, with that position, do find a necessary needed carve out or something that we can change in the PBM statutes to make sure we're uniform, I'm certainly happy to do that in February, unless there's a recommended change you have now.
Chairman, I would say that there is a possible concern with that at this point, with us having to look at enforcement or overview of the PBM manager position coming up here, that could be a possible conflict or a possible problem. I don't know if there's a way to carve out just any reference to that chapter 52 with regard to the pharmacy benefit managers. But it was something that did pop out to us or did stand out to us as being a possible concern.
Can you solve the concern by next February if we give you 8 months to figure out if there's an amendable change you need or a reinterpretation or a regulatory fix?
I believe we can.
Excellent. Questions for the Department of Insurance? Not seeing any, but if you would work on, and
Yes.
there is something more certain.
We will
I think
get you
that's easy to
language.
entertain. Senator Barlow has a question. Go ahead.
Thank you, Mr. Chairman. So my question for the Department of Insurance, and I think for the edification of the entire body, is the applicability of a state statute over all the insurers in the state of Wyoming, insurers, because the way I would look at this is that this will not cover every insurance carrier out there. So would they speak to that? Thank you.
Ms. Howard.
Mr. Chairman, Senator Barlow, yes. Just like everything in the insurance code, there are things that we have authority over and there are things that we do not. In relation to overpayments and the 2-year look back period, we would not have authority over, certain plans like self-funded plans, ERISA plans, things like that. So it would only apply, in our opinion, to the types of insurance plans we do have authority over.
Makes sense. All right, and giving you more enforcement authority and teeth is probably a conversation for another day. Do you have a follow-up, Senator Barlow?
Thank you, Mr. Chairman. So in light of that response, what percentage of the covered lives in Wyoming would this be applicable to, just like it would other state statutes are applicable to? Thank you.
Ms. Howard, if you know.
Mr. Chairman, Senator Barlow, that's a hard question. I don't know if I have those statistics right off hand. It might be a better question for the insurers, knowing their demographic of health plans. I'm sorry, I don't know. We have 1,100 insurers licensed in the state and thousands of policies, but what the percentage of what we govern and what falls under, I don't know.
I think earlier we heard at least the largest in the state has 125,000. So throw on another, 10%, and
That's
getting
always been, Mr. Chairman, if I may, there's always been a struggle of what the data of what insured falls where, right? Because not everybody is reporting the data necessarily to the Department of Insurance. Some of these groups, right, we don't regulate. So that's always the hard question. And Senator Barlow, I apologize because that's one that comes up often and I'm still working to solve it.
Further questions? Seeing none. Thank you much for being here.
Thank you.
Representative.
You have a
Swan.
follow-up? Or let's go to Senator Barlow and then we'll go to Representative Penn.
Thank you, Mr. Chairman. So I just wanted to be clear with that line of questioning that we don't know what the actual extent of the effect of this legislation is, just like we could say the same argument for the previous piece of legislation as well. But I think that is something we should try to ascertain or have a better idea so that we know that we are not actually covering and providing relief for all of the citizens of Wyoming who may have health coverage. So I think that's important to keep in the context of all of these conversations. Thank you, Mr. Chairman.
And Ms. Howard, if you can kind of look through for an upcoming meeting on generally what percentage of the population is governed under you through the plans and the insurers you regulate, that'd be great. Representative Penn?
Yeah, thank you, Chairman Zwanitzer. So I was just wondering why the 2 years and why not shorter? 2 years seems like, and maybe it's currently longer, obviously, but still 2 years seems like a long time for someone to come back after they've already paid and said, oh, guess what? We already paid you. As Mr. Boley said, you know, if they knew what they were working with from the get-go, then it seems like maybe a year shouldn't be enough. So why the 2 years and could we do a year?
That's a policy question, unless Ms. Howard, is there a reason we can't do a year in your opinion?
Mr. Chairman, Representative Penn, in our opinion, you know, there's not a reason maybe to that you could not do the year. That's probably from a regulatory standpoint as an agency. You know, as an insurer, I can't speak to that or a provider, but from a regulatory agency, no, there's not a reason. But and Representative Penn, I apologize, I don't know why the 2 years was selected. It's not our bill.
I think it was at my suggestion after the last meeting when we brought this topic up that we don't have anything, and 2 years was easy to agree upon as a starting point. But I probably will ask maybe our largest insurer in Wyoming to come up and see what their thoughts are. If it could be 1 year, if there are reasons, if that works.
Thank you.
Thanks. Oh, you have a question, Representative Ward?
Thank you, Mr. Chairman. A question for you. So isn't it 10 years now, effectively?
Right now, having nothing, LSO believes that 10 years is the general statute on what liability? I can't remember what Ms. Adams said, but having nothing else in statute, we basically allow it to go back 10 years. Is that correct, Ms. Adams?
Chairman Swanitzer, yes. So the general statute of limitations for claims that are based on a written contract is 10 years.
All right, thank you much. Hey, Blue Cross Blue Shield, since you're in the back of the room. I'm certain we pay claims timely and always within 1 year anyway, but thoughts on if it makes a difference, at least to your company, the 1 year versus 2 years or longer or shorter. Welcome back, Ms. Roday.
Mr. Chairman, members of the committee, Heather O'Day again, Blue Cross Blue Shield of Wyoming, and also joined by Raymond Red Jr. and Chris Urbanic. So we were okay with 2 years. That was certainly an improvement over 10. And I think that's fine. I think that regarding the amendment that was proposed by the Hospital Association, I think we'd really like to see it. But then I think Mr. Red has some thoughts about that too.
So I'm pretty certain without having the actual language in front of us, it is tough to craft an amendment. And I'm certain Mr. Boley will bring that to a session if the bill passes. But specifically on the 1 versus 2 years, do you guys have thoughts? Or shorter or longer time frame? Is there the data you have suggest that we could make it 6 months, or is 1 year safe? Mr. Red.
I think, you know, without having time to consider a shorter time period, we were okay with the 2 years. I think a shorter time period would be more difficult and more challenging. I mean, in order to track this type of stuff, it does take time. And, you know, there are opportunities that we've lost out on in recouping overpayments. And I think that does affect, you know, our members and those that pay premiums. And, you know, we should be diligent in keeping track of that when an overpayment is made. But if an overpayment is made, I mean, that's an overpayment. That's, you know, that's money that is not really entitled to be paid to that particular provider. And it's really, in a legal sense, unjust enrichment for a service they did not provide in some cases. So from my perspective, I do think that we should be tracking that. And that, you know, if a provider relies on an overpayment, doesn't really account for that, and then we come back 10 years later and try to take it back, that doesn't seem completely right. But to make it super fast in 3 months, oh, you made an overpayment, can't take it back, seems extreme. So the 2 years seemed appropriate from my perspective, Mr. Chairman.
Okay, questions for the Representative Ward?
Thank you, Mr. Chairman. Can you comment on how far you look back now?
Mr. Rad, if you know.
Yeah, we don't have a policy on that. Contractually speaking, the 10 years is something that we can go back that far. But I know that I've been involved in instances where we've found overpayments that were, you know, approaching that distance, and we realized that it would not be fair and not appropriate to go back and do that. So I think we look at it on a case-by-case basis, knowing that there is a certain time frame by which we could, you know, approach being 10 years potentially, but we don't necessarily have a policy on it right now. So I have worked on matters where we've gone back over 2 years and had discussions about recouping an overpayment. Other states do have statutes like this, and we've dealt with providers in other states that have not provided us with overpayments. And most of those states and most of those statutes that I've reviewed have been around 2 years. Any statutes that are quicker than that, I think there's a lot of disputes with the payers and the providers in that space, and the legislation has changed in a couple of those states to make it so that it isn't quite as swift. But we don't, to answer your question, Representative, sorry, we don't have a policy on that right now, and I can't give you too many specifics other than those examples that I provided.
Senator Bouchard.
Thank you, Mr. Chairman. You know, I'm having a problem here because we're calling it overpayment, but when I see this, I see it as clawback. And I really think that you have enough bean counters to figure out something in a year. And so I'm inclined to go with a year for that reason, because I don't think that you guys have a shortage of people that actually track those numbers. And there should be a database that has all that information. If there was truly a real overpayment where it was a mistake, that should be able to be caught in a year. But this is so broad that we've been using it to claw back. And we've heard the testimony from, I mean, heck, we're going to lose another pharmacy in Cheyenne now. And I'm sure clawbacks have a lot to do with that. So.
Not sure there's a question
Yeah.
there, but if you want to respond, and you're welcome to. Mr. Red.
Thank you, Mr. Chairman. Senator Bouchard. Yeah, there's a couple things there that I can't really respond to. I think, you know, I'm not sure about the pharmacy in Cheyenne. I think they might be selling to Walgreens, but I'm not completely sure about that. I don't know. But with respect to clawbacks and the bead counters, as you referred to them, I think we've got employees who work in our finance department, and we do try to keep track of overpayments, but health insurance is extremely complex. There's payments going in, payments going out, claims being made, adjustments to claims being made, incorrect claims being brought in that are miscoded. It is extremely complex. It takes hours and hours and time and technology that is still advancing. Even the largest health insurance corporations in the world, it's still advancing. These overpayments are not something that we want to make, but I do think it's not really a clawback in the sense that we're saying we paid you money and now you need to pay us back. It's an overpayment. It's a payment that we made in this process, this complex process, that was more than should have been made. And so I think there's some fairness there. And it goes to our members, really. We're talking about our members who are paying a premium. And if we make an overpayment of $200,000 because, by accident, because the claim was miscoded, and after 3 months, we can't take that back because of an accounting error, that seems problematic from my perspective.
Representative Trujillo.
Thank you, Mr. Chair. How often do you guys balance your books, audits, budget?
Mr. Red.
Chairman Zwanitzer, Representative Trujillo, I can't answer that question. I'm not an accountant. I'm an attorney for the plan, but we can try to get that answer for you.
Follow up.
Please.
How much was your overpayment last year?
Chairman Zwanitzer, Representative Trujillo, that I don't know either, but I do think that we could probably get some representative numbers for you on that. There's different factors that come into play, with respect to our pharmacy benefit manager and overpayments that they may have made, and then overpayments that we may have made, and other plans, other providers in other states. I guess I would ask what type of universe we're looking at, all the payments that we made or just payments to providers in Wyoming that would be representative of what the statute would capture.
And I would think if you could, those numbers for us in February of maybe what on a yearly basis overpayments you've had to ask for back. I can't imagine it's a very common occurrence, but perhaps it is, and perhaps it's a lot more money than I'm thinking it is. But I would imagine you could check with finance, and on a calendar or fiscal year basis, you could say, hey, here's what we had to either ask back or write off or whatever it is. If that's possible and easy to do, I'm sure we would request that information when the bill gets heard in the legislature in 2024. Mr. Red.
Yes, thank you, Chairman Zwanitzer. And I would say, I think we can look into that. There's a couple factors that come into play in here too. We're talking about just a straight overpayment that might be an accounting error. We could also be talking about coordination of benefits. So there was a primary payer and a secondary payer, and we should have been the secondary and we paid as the primary payer. It may also be a subrogation matter too, having to do with a third party making payments, and then we made a payment and there's dual payments being made. So we can look at the universe of it, try to figure it out. Yes, certainly in Wyoming, and at least come up with some numbers that make sense and can kind of flesh this out a little bit.
And perhaps that's a good reason not to have just a 1 year when you have other payers involved and a couple of national corporations that you might not be able to meet the statute based on other people's accounting networks and us finding out about errors in time. That's what's occurring to me. Other thoughts? All right, we'll get you off the hook. Anybody else want to talk about the 2-year? I'm fairly confident if the committee approves a 2-year, we'll have the amendment for 1 year in session. If we amend it today and make it 1 year, we may have to, go back to 2 years. So I'm not maybe caught up on the number today, but certainly would ask the insurers and anyone else to bring more data when the bill comes forward on what that number should be. Maybe it's 18 months that we can guarantee, right? Nobody wants accounting errors hanging out there too long. Any other public comment on that bill draft 30? Seeing none, we'll close public comment. Committee, do you have a motion or a pleasure on this bill at this time? Move it. Senator Baldwin's asked to move the bill as a committee sponsored bill. So 2024, seconded by Senator Dockstader. Any amendments or discussion? Senator Baldwin.
Thank you, Mr. Co-Chairman. I would like to amend, I believe on page 2, LSO can point me to exactly where it needs to go in, but I would like to add the amendment that would say all health insurers will provide hospitals and healthcare providers with fee schedules annually and upon request.
Is there a second before I ask for discussion? Second. Seconded by, is it Senator Dockstader? Okay, discussion on the amendment. LSO, can you track that in where it would go on short notice? Ms. Adams, do you have that for us right now? But it would basically ask in statute for a fee schedule each year and then
Annually and upon
request to make sure it's not updated,
right.
Or if it is. Okay. Representative Ward.
Yeah, thank you, Mr. Chairman. And Chairman Baldwin, could you just explain the reason for your amendment?
Sure.
Well, certainly.
Senator Baldwin, go ahead.
I'd be happy to represent it. And I think the reason is that I think that there's probably insurers out there that are not providing those fee schedules, and consequently, our healthcare providers, our hospitals, our doctors, whoever, don't know where how their billing falls. Are they billing appropriately? Are they not billing appropriately? Does not fall within the means. And I think if we provide those means, that fee schedule's out there, they'll know where they're billing. There's likely to be less overpayment that happen because they'll know where they're supposed to bill, and it should fall within that billing or closer, certainly. That's my reasoning. Is I think they need to know the rules before they bill. And I think if we do that, I think appropriately we'll have less overpayments.
Other Representative Ward, follow up?
Thank you, Mr. Chairman. Senator Baldwin, could that result in sort of price fixing?
Senator Baldwin?
I'm not sure I understand. Can you clarify that?
Representative Ward?
Thank you, Mr. Chairman. Well, if they have to publish a fee schedule, then other competitors are going to compare that and say, well, that's what we should be charging too.
We'll just say competition in the marketplace is good sometimes, if everybody knows what everybody's charging, I suppose.
And I would say that I think it happens in numerous, not just the healthcare industry, but I think it happens in law, in several industries. And I think it is a good competition. I think and it helps the consumers ultimately. When the consumer knows what's being charged and that's available to them, I think they'll make better decisions.
Okay, other discussion, Senator Dockstader, and then we'll go down to
Chairman,
table.
we're probably resolved on that, but and this isn't a good comparison, but I look at our fuel providers up and down, and it takes one to drive the price down, and there's one that repetitively brings the gas prices down if they're in your community. If you're the other gas station owner, look out, because it'll bring the prices down. And that's not we're talking healthcare and gas here, but it just tends to drive competition.
I mean, I think most of the big providers, they publish their fee schedule. People know how to bill appropriately, but perhaps for all of the actors, and I don't know if we can regulate everybody or not, just the ones that are domiciled here in Wyoming, which aren't as many. Representative Hornock, give a thoughts, discussion?
Mr. Chairman, thank you. Yeah. Just a kind of my question on this would be, are we then sort of interfering in a contract already made? We heard earlier that there's contracts between the providers and the insurers. I think that within those contract parameters, I mean, I get emails and mail all the time from my insurance companies telling me that things are changing this way, things are changing that way. So I mean, I can imagine a situation where this doesn't happen already, but shouldn't it already happen? Are we just confusing something in the bill that's gonna create problems for actually meaningful legislation in a piece? Are we adding something to this that's gonna kind of hamstring it through the process? Is kind of where I'm going with this.
I don't know. Elisa, did you have time to kind of get that draft language figured out where and how it's going to read? Senator Baldwin, can you state the motion one more time?
I'd love to. Thank you.
Please,
And I would, answering the last question, I don't think it hampers or hamstrings. I think it probably improves the legislation and what we're trying to do. And to restate that, my motion would be to add, and I believe it would be on page 2. I would leave that to LSO where it goes, but I would say that all health insurers will provide hospitals and healthcare providers with fee schedules annually and upon request.
By the facility or provider, I'm just making sure we're not getting into private contracts and having anyone have to share what their individual fee schedule is for that facility or corporation. That's not part of the motion. It's still a private contractual relationship between what the fee negotiated each year are.
Right. This is between the insurer and the healthcare provider.
And maybe we'd have to adjust the effective date of the overall bill to a calendar year. Because if it goes into effect next July, you might.
I would say, and it would be my movement that be on a calendar year.
Okay. So, well, I think about that. Senator Barlow, go ahead.
Thank you, Mr. Chairman. I think part of this conversation, this amendment, I will not support sending this bill onto the session if this amendment passes, because this is a conceptually new idea within this bill. So I think if we're going to add this amendment, which I'm fine to add, let's not send it onto the session. Let's have it actually review it at our next meeting, because this concept is, I think, significant. And the significance I see is network versus in-network versus out-of-network, because that is actually probably one of the more profound questions that's out there about how providers are reimbursed and when they come in and out of network, related to when services are provided, et cetera, et cetera. So I think if we're going to advance this concept within the bill, then I want us to actually examine it. I think we must examine it at our next meeting so we understand its consequences within that context of in-network versus out-of-network component. And also remembering we're not covering all the insurance providers out there. Let's just be honest about what we're telling the public with what we do. Thank you.
Thank you. So the only concern is the motion on the floor is to advance this to session. If the amendment gets put on it, it's still going unless the motion gets denied. So keep that in mind, committee. Other discussion on the amendment? Senator Bouchard.
Mr. Chairman, I just don't see a reason for this amendment. I think that unless the stakeholders come up here and tell us that they're not communicating with the providers, I just don't see where this is going. And I think the contract issues are an issue. We shouldn't be meddling in there too far. So I think the bill in its original concept is good, and I think we should keep it clean.
Other discussion on the amendment? Seeing none, all in favor of the amendment, please say aye. Opposed, say no. That amendment does not seem to have passed. We're back on the bill and the motion. Any other discussion or amendments to the motion?
Mr. Chairman.
Senator Barlow, go ahead.
Thank you, Mr. Chairman. So in the staff comment, there is a comment about the fraud being a 4-year. So and this is maybe a technical question for LSO. Should we actually have a notwithstanding fraud? It's 2 years. Because the way I read the staff note, the court has said whenever fraud is discovered, that's when the timeline begins for that fraud. So I don't know. Like I said, I don't know if it creates a kind of conflict without that amendment, but I think that we need to keep in mind that if there's a belief there's fraud involved, that can occur anytime within 4 years, not within just the 2 years. So anyway, just a thought, Mr. Chairman, and maybe some comment from our LSO staff. Thank you.
Ms. Adams, thoughts?
Chairman, Senator Barlow. So we carve out unless the claim was fraudulent, the statute of limitations for fraud is 4 years. And then that 4 years starts from the actual discovery of the fraud or when it could have been discovered.
Thank you, Mr. Chairman. I just want to point out that on page 2, it says unless the claim was fraudulent.
Very true. Other discussion? All right, seeing no further discussion, committee, all those in favor of the motion to make, let me say it right, 24 LSO 30, reimbursement of health insurance overpayments, look back, a committee bill for the 2024 session. Well, I guess I need a roll call vote. Let's do a roll. If you'd call the roll, Katie.
Thank you, Mr. Chairman. This is a roll call vote for 24 LSO 30, health insurance reimbursement for overpayment. Excuse me, Senator Barlow.
Aye.
Senator Bouchard. Senator Dockstader. Senator Hutchings.
Aye.
Representative Chadwick. Aye. Representative Clouston.
Aye.
Representative Hornock.
Aye.
Representative O'Hearn.
Aye.
Representative Penn.
Aye.
Representative Trujillo.
Aye.
Representative Ward.
Aye.
Representative Yin. Excused. Senator Baldwin. Chairman Swaniter.
Aye. Hey, we have first committee bill. And we'll discuss, I think, after Saratoga, how to divvy up the work for the budget session. With that, while we're still on prior auth, 24 LSO 14 Medicaid third-party payer conditions, Wyoming Department of Health. pleased to be joined by Director Johansson today. And also, I think they're coming up to join you here, Mr. Grossman and Dr. Johnson. Miss Adams is coming too. Did you want to actually present this one, Katie? I know it was asked for by the Department of Health, so, but if you want to at least kick us off, certainly do.
Chairman's Monitor, Katie Adams, LSO. This bill draft contains 2 amendments that the Department of Health requested at the April meeting. Section 424204 of the Medicaid Benefit Recovery Statutes is amended to require health insurers or parties responsible for payment of a claim to agree as a condition of doing business in the state of Wyoming to, under Romanet 3, respond within 60 days to any inquiry by the state regarding specified claims for payment. And then under Romanet 4, not deny a claim submitted by the state solely based on failure to obtain required prior authorization. There is a staff comment explaining that we streamlined the language the department recommended for subsection E4, and then the act would be effective July 1st, 2024.
Questions for Ms. Adams? Seeing none. Thank you much. Director Johansson.
Thank you, Mr. Chairman, members of the committee. Stefan Johansson, Director for the Wyoming Department of Health. I'm joined by Lee Grossman, our state Medicaid agent to my right. And I'd like to introduce the committee to our relatively new Medicaid medical officer, Dr. Paul Johnson, who joined us about 3 or 4 months ago. A talented physician and just a big asset to the department in his brief time here. So we're very happy to have him on. If I may, Mr. Chairman, I'd also like to introduce you to an intern that we have in my office, Amelia Horst, sitting in the back. She can wave. She'll be going into her 2nd year at University of Wyoming. And as you can imagine, interning and learning under Mr. Franz Fuchs, she is drinking out of a fire hose. So we are happy to have her for the summer. And as a Kemmer native, really glad that she was able to join us and observe the committee today. Mr. Chairman, we'll hopefully save you some time here. This is a somewhat of a statute cleanup that we had presented at our last committee meeting in Casper. And it's just some small tweaks, as you can see, that guarantees in our what we call our TPL or third party liability provision in Medicaid. And to put it simply, it's when we chase payments that should have been made by primary insurers where Medicaid is either the secondary or shouldn't be the payer. Think auto insurance policies, things of that nature, that the state can collect essentially what it's due to limit the exposure on the state financial side when appropriate. So mostly a cleanup here. You can see there's just a small amount of language, and we really appreciate LSO's assistance in streamlining this and making it what you see in front of you today. With that, happy to hand it over to Mr. Grossman if there's any other details he'd like to add, and then certainly could field your questions if you have any.
Okay, Mr. Grossman.
Mr. Chairman, members of the committee, Lee Grossman, State Medicaid Agent with the Wyoming Department of Health. I'll cede some time back to your agenda. I think the director hit all the highlights. We see this as a simple cleanup bill and clarification. In order to make sure again that the Medicaid program is recovering the money that is entitled, and also making sure that we are the payer of last resort, which is our statutory obligation. Okay. And with that, I'd be happy to answer any questions.
Questions, committee? Putting in a timeline and specifying what's like 2 amendments of prior failure to obtain required prior. All right, seeing no discussion. I do now. Senator Hutchins.
Thank you, Mr. Chair. For some reason, I wrote on my notes on page 2, lines 22. Why were these original stipulations? That is Romanet 4. When it says agree not to deny a claim submitted by the state solely on the basis of the date of submission of the claim, the type or format. It's kind of like, why is that put in there? I'm gonna agree not to deny your claim when you submit it maybe years later. I don't know why that's there.
Mr. Grossman, go ahead.
Mr. Chairman, Senator Hutchings, that I would describe that as if the Medicaid program is going to recover money, let's say from an auto insurer that should have paid for a service, that said insurer could not deny Medicaid seeking that reimbursement for those purposes. So say we didn't use a specified form, or with the proposed amendment here that we did not seek prior authorization in the manner that that private insurer requires.
Trying to work with a myriad of different insurance companies who could find various reasons like, oh, you didn't submit it based on the first of the month. Any number of things people could deny you for. When it comes to Medicaid, we basically say, take it or leave it, but everybody takes it because it doesn't pay that much. But yeah, it's pretty standard language, I would think, across the board in all state Medicaid programs, right?
Yeah, Mr. Chairman, that's correct from our estimation and knowledge. Again, really making sure that it's not a procedural reason, that it would be a material one in which a third party insurer would be denying Medicaid's claim to reimbursement.
Okay. Yep. Further questions, Representative Ward?
Thank you, Mr. Chairman. Aren't there some providers who do not accept or pay Medicaid?
Go ahead, Mr. Grossman.
Mr. Chairman, Representative Ward, that's correct. There's some, while we have very high participation rate, especially within our healthcare providers in the state, there are some.
Thank you, Mr. Chairman. So then how does this apply to providers who don't pay Medicaid?
Mr. Chairman, Representative Ward, if I may, so this would be collections from third-party insurers, not providers. So say a Medicaid member gets in an auto accident and has auto insurance, and we have claims for in Medicaid to pay the provider for whatever treatment was rendered, but the auto insurance policy should have paid first. We would be chasing reimbursement from the auto insurance provider, not the healthcare provider.
Okay, seeing no other questions, you're off the hook. Any other public comment on this change? Not seeing any in person, not seeing any online. With that, committee, what's your pleasure on 24
Chairman.
LSO draft 4? Senator Barlow, go ahead.
Mr. Chairman, I
Question?
would,
Yep.
thank you, Mr. Chairman. So I would make sure that we're thinking about the prior authorization language in this, because that will be impacted by the bill that was put forth, the first bill we took up. So as we consider this bill, we are now identifying what prior authorization, we could be identifying what prior authorization is in that first bill we took up. So there is a connection between the two. We can sort that out at session, but I want to be clear that the Department of Health keeps track of what prior authorization means, the definition of prior authorization in that other bill, and make sure it's consistent with what they're trying to accomplish. Thank you, Mr. Chairman.
Thank you. And I think there's maybe a connection, but when it comes to Medicaid, it's not. Does it still affect the other bill, Director Johansson, or you're safe on that?
Mr. Chairman, Senator Barlow's comments are well taken, especially as this committee and the legislature may establish additional standards for prior authorization. The one distinguishing factor is the bill you considered earlier is solely in Title 26, insurance code and insurance law. And in the definition section of Title 26, payers like Medicaid are not part of that authority.
All right. Any other public comment? No one online. We'll close public comment. Committee, any motions on 24 LSO draft 14? Representative Clouston is moving the bill as a committee sponsored bill for the 2024 budget session, seconded by Representative Chadwick. Any discussion or amendments to this piece of legislation, committee? Representative Ward.
A question on page 2, and I apologize if this is already covered, but it says item or service, and this is line 18, is submitted not later than 3 years after the date of provision of such healthcare. So how come this is 3 years? And then we talked about 2 years for the clawback. So I think we should be consistent.
I don't know, Director, if you want to come back. I'm assuming that's a contractual standard Medicaid language, but do you believe that conflicts with if we do put in a 1 or 2 year provision? Those are on overpayments. This is any claim for payment. Thoughts?
Mr. Chairman, Representative Ward, it's a good question. Again, different section of statute. So what you discussed earlier is in the insurance regulations, of which we are not part of as a Medicaid program. This, as you can see, is current statute language. It's been in there as far as I can remember, which is the standard established now. Should you want to discuss changing that, we certainly could, but that's how it exists now.
Okay, but you might double check and see if that conflicts with the other statute moving forward. Senator Bouchard.
Yeah, Mr. Chairman, what my question is, do we have a bunch of cases that this is going to fix the problem on? I mean, like that you can just name off to us to kind of get us on the same page?
Sure, Director.
Mr. Chairman, Senator Bouchard, I wouldn't say this is a solution to any major problems. It's more of a cleanup, aligns with current, requirements from CMS, et cetera. I'd have to get back with you on our third-party liability volume in general. I don't have those numbers off the top of my head. Again, I think this streamlines it. It makes it more efficient to collect from insurers all over the country, frankly, in some cases, like auto insurers to make it clear of what authority we have in Medicaid.
Representative Hornock.
Thank you, Mr. Chairman. To a point that was made earlier by, back on the prior authorization idea. So we're requiring those health insurers who operate within the state to agree not to deny a claim if our Medicaid services does not obtain a prior authorization. So how is this? Seems to me like we are now exempting our Medicaid coverage from having to go through that prior authorization procedure. Am I wrong about thinking that way? And why would we exempt Medicaid from doing something that we just required our hospitals to do? Thank you.
Go ahead, Director.
Mr. Chairman, Representative Hornock, it's another good question. As Mr. Grossman mentioned, it's really denying solely on the basis of procedural issues that would change here. So, forms, dates, prior authorizations. Again, this isn't a prior authorization for a service that we would be paying for. It's for a service that we've identified one of our members' primary insurance coverage, whether it's health, auto, or otherwise, should be paying that claim. And so when we seek reimbursement for that, this allows us to not be denied for solely procedural reasons. And Lee, feel free to add anything I missed.
And I would just also add one more statement, Mr. Chairman, Representative Hornock. So by recovering that, essentially to your question, by being exempt from needing that specific provider's prior authorization, if we're denied by an insurer, right, that just means that we're not able to conserve or bring back that public funding to spend as it's intended, essentially in the Medicaid program. So again, we feel this is an efficiency, especially from a budget perspective. As the director mentioned, we don't think we're talking about a large amount of dollars here, but certainly every little bit helps when we're talking about how we use these Medicaid funds responsibly.
Okay. Further questions, discussion? Seeing none. Senator Hutchins. We kind of closed public comment, but stay there anyway. Go ahead, Senator Hutchins.
Thank you. Kind of piggybacking on what Representative Hornock was saying, instead of putting failure to obtain required prior authorization, why don't you put in what you're saying to us, that it's a procedural issue? Because the prior authorization, it kind of stumps me too. It's like, we didn't get prior authorization, but we want you to pay it anyway. And you're saying that, no, it's a prior, it's something on your contract that says you will pay, but you're not paying. Why don't we word it the way that it should be? So you're not thinking that it's a prior authorization. If
Medicaid
that makes
is
sense.
special. Director Johansson, thoughts?
Mr.
Kind of
Chairman,
Spinning in my head.
Senator Hutchings, I agree. This is a spinny one. But I think to clarify, this is language that's standard now across Medicaid programs and federally required. So again, not to be redundant, but I will be. We believe we need this language to be able to chase the reimbursement that Medicaid is owed. And for anybody doing business in the state of Wyoming, it would be a requirement. And so not denying on prior authorization alone is something that we believe we need in the statute. So I wish I could be more clear. Lee, feel free to add anything you'd like. Trying to navigate that balance here, Senator Hutchings, but relatively small amount of dollars we're talking about.
Right, Mr. Chair, follow up. This kind of brings back why I think I asked that first question about why are you, was this in the original contract? You know, my feelings on Medicaid, and I'm hearing we're doing what the federal government is telling us to do. We have to do it this way because this is what they're telling us to do. What happens if we don't do it?
Sure, and Mr. Griffin, this is in our citizens' best interest to try to recoup the money when we can from other insurers. But if you answer Senator Hutchins' question.
Mr. Chairman, Senator Hutchings and Mr. Chairman, I think that's our sentiment here exactly. Obviously complying with federal laws, you know, what we want to do in the best interest of the state and the program, but certainly, you know, to some of the prior questions as well. This is something where we can make sure that Medicaid is ensuring that we're the payer of last resort, which again is a statutory obligation. But if I can go back, Senator Hutchings, to your prior question of sort of exempting Medicaid from prior authorizations, if you will. If you play this, the scenario that we're walking through, again, it's relatively rare. So I don't want to give the impression that this is a daily occurrence. But let's say you have a Medicaid member who gets in an auto accident, and by the time there is an identification of the fact that this is a Medicaid member, maybe that auto insurance company has already paid out some claims, right? And so it would have been essentially impossible, right, absent a use of a time machine here, right, for the Medicaid agency to have sought prior authorization if we as a state agency were not made aware. So I just hope perhaps that real world circumstance just gives a little bit of context that, you know, the Medicaid program isn't trying to do our due diligence here. It's that by simple awareness of someone receiving care, and when the Medicaid program was essentially attached to that individual's care, we would not have been able to have even sought that procedural prior approval.
Thank you. You said a few things that clarified it for me. Thank you.
Thank you. All right. Any other discussion among committee members or questions about health while I have them? Any other amendments? Seeing none. The motion on the floor is for a voice vote on making this 2024 committee bill. Katie, you're calling the roll. Go ahead.
Mr. Chairman, this is roll call vote for 24 LSO 0014, Medicaid third-party payer conditions. Senator Barlow.
Aye. Aye.
Senator Bouchard. Senator Dockstetter. Senator Hutchings. Representative Chadwick. Representative Klauston.
Aye.
Representative Hornock.
Aye.
Representative O'Hearn.
Aye.
Representative Penn.
Aye.
Representative Trujillo.
Aye.
Representative Ward.
Aye.
Representative Yin,
Excused.
excused. Senator Baldwin.
Aye.
Chairman Zwaniter,
All right,
13 aye, 1 excused.
excellent. And Vice Chairman Yin does keep jumping in and out of the Zoom. He just apparently can't seem to make it on when we have a vote. So hopefully for our next one, I know he's at a conference in Philadelphia today. With that, we're going to keep on going. I think the next topic on our agenda is Cigna, because we're already at 10 o'clock. I know people have been patiently waiting. And so committee, this was a new kind of addition to our agenda on short notice based on some things that were going on that came to light about 3 weeks ago. And I'm sure you heard from many of your constituents, as I did, about, I guess, business activities that we may or may not be able to regulate. I don't know, Representative Clouston, I know it kind of affects your line of work, and anything you wanted to kind of say to kick us off on if this was kind of a maybe just a background for the committee. I think we've all received multiple emails, but at least for maybe other members of the public who didn't get the same emails we did and know exactly where this issue arose from, if you had any opening comments before we hear from some of the more national people. Go ahead. Representative Ward.
A procedural question. So I thought that we had to get it approved by management council to add something to our agenda.
Yes, and so I talked to Chairman Baldwin and we agreed this was a topic that fell under emerging issues that we were just discussing. So at this time, there's no legislation. It's just a topic of concern.
Right, because last time I brought up a topic of concern and we voted up and down on it. So do we have to vote up and down on anything that's added to our agenda?
Generally, from what I understand, and also can correct me, if your co-chairman believe it's an issue that needs a hearing or topic or witnesses to come, we can order it. But yes, otherwise for non-chairman to say they want to add something not from management council on the agenda, we generally vote on it.
Okay.
I mean, at LSO, is that your understanding of the process as well, Ms. Johnson?
Mr. Chairman, I'd leave that up to your discretion.
That's my discussion. Representative Clouston, thoughts?
Yeah, we've heard from a lot of our constituents in the state of Wyoming that Cigna, who's our state TPA, is working with a group called, acronym is ASH, American Specialty Health. They've been informing our outpatient physical and occupational therapy clinics that they would be cutting our reimbursement basically 50% and bringing in some very strict prior authorization rules. Also, Wyoming has direct access, so we don't require a physician's order. The contract being presented to our practitioners in the state of Wyoming would go against Wyoming law and would also require physician referrals. So this is a reimbursement issue for our providers that are already trying to provide care in our rural state. It's also a direct access and a prior authorization change to what we're used to. So there's been a lot of meetings, hundreds of letters sent out, lots of phone calls. So it could affect us on the state level as well as our private practitioners in the state of Wyoming.
And I think committee, you'd get a handout today or an email that 315 of our providers or their staff have signed with certain requests that you can read through that email, but I believe they wanted us to know they had 315 signatories. With that, we are privileged to have the Assistant Vice President of Cigna, Joe DiRenzio, joining us. Mr. DiRenzio, or Senator Barlow, do you have opening comments or thoughts before I turn it over?
Thank you, Mr. Chairman. So while we've heard this in the context of physical therapy, what my query will be is, are there other practice areas that are also receiving these letters, et cetera? So as we go forward, if that could come to light, because I've heard of one practice area, but I don't know if that's just the first ones that got the letters. Thank you, Mr. Chairman.
I believe that's correct. And we'll hear from several people with Cigna and ASH as well. I think we'll start with Mr. DiRenzio, if that's okay, unless you'd like us to start somewhere else, but go ahead, Joe, the floor is yours.
Thank you very much, and good afternoon, everyone. Thank you, Mr. Chairman and members of the committee. I appreciate the opportunity to speak with you today about Cigna's relationship with American Specialty Health, or as was said, ASH. We're calling in from New Jersey, and with me today from California is Bob White, who's the president and COO of American Specialty Health, and Shelley Beard, who is on my team and is our regional director for compliance. I've never been to the great state of Wyoming. I would have liked the opportunity, but I know with the timing, we weren't able to make it out there, but should we need to speak again, we'd be more than happy to come out. We also understand, as previously stated, that you have a number of concerns regarding the coming changes to the administration of Cigna's physical and occupational therapy services, and I'm hoping to provide you with our perspective on that issue. ASH currently administers physical and occupational services in 25 Cigna markets across the United States, which means they're delegated for contract administration, network management, medical necessity review, not prior authorization, and claims processing on Cigna's behalf. Effective September 1st, 2023, we've begun to expand our relationship with ASH to additional 13 markets nationally. We deeply appreciate and value the concerns from the provider community, which is why we're here today to address them. And thank you for the opportunity to speak with the committee today. And I'm happy to answer any questions at the appropriate time. We have a presentation which is up on the screen. I want to make sure everybody can see it right now, and we could walk through it if that's your preference. So thank you.
Is a presentation, like a 3 to 5 minute presentation, Mr. Dorenzio?
Yes,
certainly
we
like to
could
hear a
walk
little
through
bit
it
of it.
quickly. We could walk through
Sure,
it quickly.
please do. If you would, or whoever you have designated, that
Sure.
would be great.
So Margaret on our team will forward the slides, but I'll speak to them. So very quickly, American Specialty Health has been selected by Cigna to administer these programs within Cigna. And it really crosses all of our products, which would be commercial, Medicare, and individual health plans. As you can see, it's a broad-based offering. It is our clinical philosophy, and I'm not a physician, but I work very closely with our clinical leadership team to create a broad base of services that are conservative in treatment and may avoid more costly and more invasive care that may not have the best outcomes for our customers. So we really encourage the use of these networks, and we're very proud that we've expanded them significantly over the last several years. To the next slide. So just touching on some of the high points, you may ask, why does Cigna use American Specialty Health? It's always a question for a health plan to say, should we build it ourselves, or do we delegate to a vendor like American Specialty Health? In this case, as we go out in a market scan, we realize that American Specialty Health is distinguished and also accredited by major accrediting organizations like URAC and NCQA, and they can efficiently manage these networks. And we manage them through a contractual arrangement, which we review very often and annually to make sure they're meeting our expectations. As you can see, they have specialized expertise in the management of these services, which we'll call physical medicine services, and they use evidence-based clinical guidelines to manage these services. Evidence-based is, and I'll let Mr. White speak to it, but the evidence base is developed between Cigna and American Specialty Health and is co-branded and available to all our providers to reference. What this does, it has the effect of avoiding overutilization and fraud, waste, and abuse. And in addition, it assures that we credential only the most qualified providers in our network, which should procure patient satisfaction and overall quality. Next. This is a bit of a lengthy slide, so I'll just touch the more important parts. As you can see under medical management, and again, this is not prior authorization, this is medical necessity review. The availability to review those services are available pre-service, concurrently, post-service, and we have peer-to-peer readily available to the providers. We also educate clients and customers about the cost of these services so they can make informed decisions about their out-of-pocket costs. Very important to us is the provider network adequacy. We want to be able to have a broad network. We want to be able to service all of our customers wherever they may live and have, as I said, a high quality network through our credentialing process. Next slide, please. So with regard to physical and occupational therapy, which was the discussion at hand today, we understand very importantly as a health plan that we have an aging population and people are living longer. There's increasing mobility issues. You have joint replacements stemming from chronic conditions like osteoarthritis, comorbidities like diabetes and obesity. Evidence supports that early and appropriate physical therapy in a customer's care will offset downstream expense. Degenerative spine conditions in the aging population creates more need for physical therapy and avoid costly interventional pain management and back surgeries. So as you can see, we are looking to promote the use of physical and occupational therapy as a conservative approach to treatment and only when medically appropriate do we refer them to higher cost services. This program does not require a referral from a practitioner. According to the benefit plan, a customer may choose to visit any physical and occupational therapist that is within the in-network provider directory. And I believe that concludes the slide presentation. So we are open, and I know we have Mr. Moser present, and we also have, as I said, the panel here today to answer any questions that you may see fit. Thank you for your time.
Thank you. And Mr. Mosier is present. I just jumped right into you since you were on the, we normally let, the Wyoming people introduce their people, but certainly appreciate you going first and presenting that. If it's okay, committee, I might have all of the executives speak, and then we can ask questions as a group, if that's okay. So I know Ms. Reynolds, and I don't know if you all have prepared testimonies or comments, or you're just here to answer questions. But Ms. Reynolds, if you do have anything, we'd be happy to hear from you at this time.
I don't. I'll cede my time to the committee. Just here to answer questions.
Thank you. Ms. Beard, anything at the beginning?
No, thank you.
Okay. We'll find something for each one of you. And Mr. White, I know you're here on behalf of Ash, I believe. Any introductory comments?
Thank you, Chairman. Just to introduce myself, I am Bob White, President and Chief Operations Officer for American Specialty Health, and have held that role for now close to 23 years. And so I'm here to respond to questions in support of our relationship with Cigna and to support the state.
So, and perhaps, and Mr. White, while I have you and to get us going, I mean, we're not the first state you've entered into with a relationship with Cigna into our market. And I know there have been some concerns expressed from various clinics and offices and constituents on perhaps the rollout and the language expressed that, you need to do this immediately or you lose network coverage. And those of us who are maybe more familiar with the insurance world, kind of in the hospital world, know how these relationships kind of work on, I won't call them scare tactics, but you kind of come out of the gate saying, here's how it's going to be. And is that this kind of a similar method you've used in other states? Is your reaction in Wyoming different than your reaction in other states have been? Or it just seems like it kind of came out of nowhere, took a lot of our providers by surprise. As you know, we're kind of a close knit state. We all know each other, and healthcare is very expensive here. I think we're the most expensive or second most expensive in the country. And a lot of our people are at risk with the already exorbitant cost of care. So maybe just a couple of minutes on, was Wyoming kind of following the pattern, or did we do something to push back or upset you out of the gate?
Thank you, Mr. Chairman. And I will take a few moments just to provide a bit of perspective on American Specialty Health. We've been in business now 36 years, supporting the management of benefits for musculoskeletal or physical therapy benefits. In that time, we've now grown to a national organization that supports more than 150 health plans across the country with delegated responsibilities, as Mr. Duranzo described in his overview. We now have more than 94,000 contracted practitioners in multiple provider specialties that support musculoskeletal and physical therapy conditions, of which 53,000 are contracted practitioners in the physical therapy and occupational therapy provider specialty. So clearly we have done this for many years. We now serve 43 million members in that context across the country. This is not our first network support program for a client. We have literally done hundreds of campaigns across the country over the last 2 decades that I've been with the organization, and most nearly literally all of those have been successfully implemented in support of the goals of our clients. I do want to clarify in response to your question about reaction in the state. First of all, as Mr. Duranzo said, this is not a prior authorization program. A member can access care. And I will acknowledge that the language with respect to the referral requirement is more ambiguous than I would like it to see. So that will be corrected. We have what we call a client summary that supports the specific relationship in a given state under our provider services agreement, and it will be designated. And we are fully aware that Wyoming is a direct access state with no referral requirement, so that is not an issue, as prior authorization is not an issue. With respect to your feedback around a few the reactions that we've seen, clearly they have been strong in some certain characteristics around reimbursement. While we cannot, for obvious reasons, to clearly protect antitrust violations, we focus on negotiations specifically with provider groups and or providers, and cannot support an engagement on specific reimbursement as it varies with each of those individuals we elect to contract with. I think what was in answer to your question, clearly we've had an overwhelming reaction to some of the reimbursement levels that exist today. And I believe one of the correspondents that came up cited as much or just under $400 for a physical therapy visit. Of all of, and we do physical therapy now in networks in more than 40 states. That is a surprise to just us in the context of, if you look at both nationally as well as states where we deal with and have done a response to rural access and limited access to care, those are frankly running between 2, 3, and 4 times what we have normally experienced, among the highest that I personally have been informed of. Now, in that context, that information is important to us, and we respond to it, and we address those that feedback in our negotiation process to support the transition of the network in support of Cigna members. So it is not uncommon to deal with a range of different reimbursement levels based on many characteristics to reach ultimate agreement on what reimbursement should be. And we expect to do that in the state of Wyoming, as we do with any other state. And we listen very, very closely to the feedback that we receive. And I will pause there.
All right. Thanks, Mr. Dorenzo. Did you want to jump in there? Saw you raised your hand. Feel free to elaborate.
I just wanted to address the one comment about a surprise. We don't like surprises, as I'm sure you and the provider community don't appreciate. We work very hard to get information out in advance of the expansion of these programs. And so we've worked with the APTA to make sure that they were able to contact their constituencies as well. Just so, as you said, it isn't a surprise and they have ample time to respond and react. Thank you.
I mean, as a legislature, we normally don't get these issues rising to us, but I think for whatever reason, the kind of out of nowhere happening, and it was statewide, obviously, because Cigna is in many of our communities, and it all kind of came from everywhere all at once, and so that was why a lot of people were kind of wanting to know what the legislature was going to do about it, and why we nicely asked you all to come visit with us today. So do you have some questions for you? We'll start with Senator Dockstetter.
Thank you, Mr. Chairman. I heard the word specific. The previous gentleman said the word specific several times. So this is, each state has its own specific program. Your announcement to Wyoming, and I'll say it was a surprise as we heard it from people across the state. It's specific to Wyoming. But I also heard you say you respond to the feedback, and the feedback is simply that we've got great concern. These folks are dealing with small client bases, small patient bases, and now we're dropping the level of reimbursement. Is that enough? If we push back to you and say, this isn't working, this isn't good for our state, this isn't good for our healthcare providers, do you take that in consideration? And would there be reconsideration? Thank you.
Yeah.
Mr. Dorenzo, if you want it first.
Yeah, I'd rather speak to that. Of course, we are open to any and all feedback from our provider community, from the state legislature, departments of insurance. If there's a material issue that we need to resolve, we absolutely are open to that. So we welcome the feedback, and we will try to respond as appropriately as possible. Given that we do set timelines so that we can offer our customers and clients a robust network in a timely manner, But with that said, we are flexible and we can discuss, those issues outright and forthrightly.
So right now, is it, I think the end of July is where it was just kind of, I got confusing information because some people said, they had 24 or 48 hours where they had to agree to stipulations or go out of network. And then others said it was, a 2-month, 60-day window. Is that hard and firm on somewhere in mid-July, or is this kind of an
Sure.
evolving, working with each provider over a couple of months scenario?
Correct. I mean, we went out with notification in May with a mid-July timeframe, Mr. Chairman, feeling that that's ample time to have negotiations, discussions. But certainly if there are material issues that need to be resolved, we're always open to, pushing past that in a reasonable manner to make sure that the provider is comfortable with whatever decision they make.
Go ahead, Senator Dockstader.
How do you reach that decision? We don't legislate it. Do you do it through policy and procedure? Do you sit down and work with the state? How do you reach that decision to reconsider?
Mr. Lorenzo, if you want to
Yeah,
take that
well,
one, you can.
Yeah, I'll take that. So obviously we need to have a timeline that we need to reach in a reasonable manner. And we feel like, a May notification to July is reasonable in that sense. But if there are material issues that impact a decision, we'll meet as a group between American Specialty Health and our leadership team, work with the provider directly to understand what those issues are, and then hopefully reach a conclusion that makes sense to all parties involved. Remember that our goal is to build a broad access network. Our goal is not to limit it. It is not to provide such a barrier that providers are reticent to join. We're doing everything we can, including education, any materials. American Specialty Health will go to the offices both telephonically and live. We want to break down any barrier we can to make the provider comfortable that this is the right move to join American Specialty Health's network.
Okay. Other questions? Committee at this time? Well, perhaps I'm not sure. We'll take some public comment. I'm not sure I want the public to be asking them questions through us, but certainly don't go anywhere then online. If the four of you would kind of hang tight, we have some people here in the audience who want to testify. We'll go from them and we'll get back to you. Senator Bouchard, question? Yep, go ahead, Senator.
Thank you, Mr. Chairman. So I have a question. Isn't this all contractually done in the beginning? How do we change this? Because it was all sold to the receiver, and now all of a sudden it changes. So I'm trying to figure out how do we get to that point?
As in, these are usually like year-long contracts, then kind of 60-day notice, you got to do this and take this without maybe a 6-month or a year, then, the renewal of the plan. If you could discuss how that works. Mr. Lorenzo or.
We observe any contractual obligations that Cigna has with the provider as far as notification is concerned. That's very important to us, for all the reasons we're discussing today. And again, I would say that we believe that the timeframe we've offered provides ample time to make a decision on whether to, join the network, negotiate rates, leave the network, which is not our preference. All of that is considered, in advance of when we decide to expand a program such as this. Does that answer your question? I hope I'm responding to it directly. I may have missed a more salient point that you were trying to make there, Senator.
I think that's the point, is most of these contracts are done on a yearly basis, and 60 days, small businesses can pivot, but 60-day notice is not, it's really tough, right? It's one thing if it's coming in 6 months and you can budget and figure out staff numbers and patients. 60 days for a lot of Wyoming small businesses is probably not enough to swallow what's a pretty difficult pill, I would argue, for many of them in many of our especially rural communities. So I think that's where a lot of the consternation is coming from. But we'll hear from some members of the public. Come on down. You're welcome to be first. And then we'll check back in with our online people here in a bit. Yep. And just name and who you're with, and we'll start going.
Thank you very much, Mr. Chairman and committee. My name is Brent Kaufman. I'm a physical therapist. I'm one of the founders and president of Fremont Therapy Group. We have 6 locations in Wyoming. So, and we've been doing this for 27 years as a practice, and I've been a therapist almost 30 years. I don't know if you like us to address some of the things that have been said so far, or, I mean,
I think it's what you'd like the legislature to know, and then
yeah,
we could probably form a question.
and I suppose you guys are sitting there kind of going, what are we kind of supposed to do here? Because we're really not at, our ask is not legislation here. I think is Representative Clauston, sorry, I was gonna almost call you Ken, but sorry, I apologize. Is really looking at the state. The state right now currently uses Cigna, and it is they're the TPA for a self-funded program. So our belief is the state has a lot of control in regards to what direction they would like things to go. So I think there is some influences to be had from that standpoint. That's kind of why we're coming and talking today. If the state wasn't involved, then we'd probably just continued our united front. And to some of the comments about negotiations and things like that, there's never been anything put out there to negotiate with us. And if you want to talk about the ASH network and how they function in other states, we can talk about that. But, you know, somewhat of it's gaining a market advantage and then coming in, and I'm involved nationally in private practice as well as the APTA. And they'll come in and they gain a market advantage. And then they'll come in and basically say, this is, if you want to be in our network, we cover 100,000 lives. Well, if you want to see any of that business, you will do what we want you to do. And so when we look at what we've been doing with Cigna, which has been a relatively good relationship, granted, last year we took a pay cut of 15% on PT assistance and OT assistance, in addition to a limit as to the daily rate that we'd be able to receive from Cigna. And that was last October. So we haven't gone a full year now, and now we're switching up again. The reason it takes 60, 90, it's actually for ASH network typically because we all have to get re-credentialed. So we're currently credentialed with Cigna. That will end as of September 1st. And if we want to participate in that network, all of us have to get re-credentialed. And if you know anything about credentialing, it's not an easy process. It takes time, it takes people, it takes hours. So that's that part of it all. Then when you look at, so for us now, ASH is coming in and we just basically get a letter saying you need to sign up. You're going to lose your credentialing as of September 1st. If you want to maintain the ability to see Cigna patients in network, this is what you need to do. So that's kind of how we all found out about this whole thing. So now we're all sitting there looking, going, well, what do we do now? I mean, so we basically banded together and said, this is not appropriate. This is not good patient care. Even if you look at just the payment rate that we're going to receive, which is less than our cost to provide care, honestly, we pay attention to those metrics. The administrative burden that exists there is significant. And it's arbitrary. It's rationing of care arbitrarily. And I felt like listening to the earlier stuff that we're talking about and hearing about, it kind of fell on the same tenets that you're hearing now. So I guess that would be our big ask, is the state getting involved from their insurance and their self-funded program and influences that they may have in utilizing the ASH network with Cigna and telling Cigna, no, we like the way that things are working right now. And as to the comments of utilization by physical therapy, that's great. I appreciate those comments and those great things to hear. And obviously it's a great benefit, PT and OT, but I don't think we're getting the full story there. We're getting a siloed effect as to far as utilization going up in that part of it all. Well, what about other areas of healthcare where maybe it's going down? It was mentioned that downstream costs are reduced when physical therapy and occupational therapy is involved, and you see a reduction in downstream costs. Well, you kind of have to bucket that in the same place that where you put PT and OT, because it's an overall lessening of the cost of healthcare. And there was a study done with Medicare patients, 38,000 Medicare patients, and they use Medicare because they don't change insurances. They keep the same insurance. And it was for low back pain. And they looked at the intervention of physical therapy early on and frequently, and that population had a reduction of anywhere from 13% to 32% in downstream healthcare costs overall. So it's clearly a benefit. So I guess I'm just trying to figure out, if it's such a great thing, why are we starting to overly administer it? Not to mention you have Cigna, who obviously they're not doing this for free. And now you're going to add one more administrative layer into there. Well, that has to come from somewhere. And I would argue it's probably coming from that healthcare dollar that was designed to be a benefit to the state employee that has Cigna insurance. So to me, that doesn't make a whole lot of sense. I don't think there's a lot of fraud, waste, and abuse going on in Wyoming. We know each other. We know our neighbors. We're accountable. It's not like living in a big city, in my opinion. So do you guys have anything else to add? I've spewed
I
a
might
lot.
let all three of you testify and then we'll ask questions. Jay, go ahead.
Jamie, Mr. Chairman, Jamie Everett, I'm from Cheyenne, Wyoming, so I kind of represent that city as well, but also the private practice owners in the state of Wyoming. And this did come to me specifically. I am the president of the APTA Association for Wyoming. Ash and Cigna did send me a letter on May 17th. I dispelled that to the rest of the committee or the community. Oops, sorry. I did give that letter to the rest of our community, and then the rest of the private practice owners did get the letter on May 22nd, delivered to them exclusively in each PT. And then we were told by July 17th that we needed to sign the contract. I do get daily emails on it to sign the contract. You look through the contract, and as Brent mentioned, there's just some non-negotiable things. I can't do business. My cost of doing business right now is more than my reimbursement in that contract. Then when I asked to negotiate, they say, well, you need to sign the contract first prior to negotiation. I'm like, well, that's not how, I don't give you money and then tell them what car I'm going to get. So there's been, got nervous. There's been some problems with the manner of what they're saying that they're going to negotiate. I did just get an email yesterday with Ash Network that said that we have 3 times that we'd like to meet with the membership. And that's July 10th and July 11th. Couple of days, 6 days before the July 17th deadline that they're giving us to discuss some of these things specifically with the state. We do currently have every city right now, every clinic and every city representative. You saw the signatures. We're now up to 444 signatures. We have 984 practicing PTs. So many of those signatures are representing the full clinic. And right now, the clinics are saying, we can't do this. We can't do it. So thank you, Mr. Chairman.
Go ahead, Brent.
Oh, thank you, Mr. Chairman. One last thing I would add to this is that with the state employees, if we don't have any in-network providers, what's going to happen is that everybody that needs that benefit will no longer be in network. They'll have to go to an out-of-network provider or go to, I believe the hospitals are not affected by this issue. But that won't be the expected benefit that people anticipated when they got the insurance. And I know a lot of people, at least people I've talked to, the reason they like working for the state is because the benefits are so good. And that's a big talking point for people. And so if it's a degradation of benefits because there are no in-network providers, and look, when I started my career, I wanted to just treat patients, come one, come all, and that's what my passion was for. At some point, you kind of start to have to do the math because you start to feel these external pressures financially, and you have to make sense of it. We've got new graduate students coming out with significant student loan debt. We've got inflation just on the backs of COVID. So you've got all these different costs that have gone up dramatically. We don't have the ability to just raise our price. The lumber yard, you go down and you buy a piece of 2x lumber, and the price has gone up 30%. We don't have that ability to do that. So we basically are told by the Ash networks and the Cignas of the world that this is what we're going to pay you for the things that you do. And at some point it gets to a breaking point. You say, you know what? It can't work. And currently we deal with staff shortages all the time here in Wyoming. We use a lot of PT assistants and OT assistants. The demand for therapy is not low. The problem we have right now post-pandemically is that we are short-staffed. And this is not meant to sound insensitive, but if you get a payer source out that says this is what we'll pay you for the services you provide, and it doesn't make sense financially, and it's going to overwork your staff, you're going to say, well, then maybe what we can do is absorb where we have the ability to actually do more with the other patients that we have currently because we are short-staffed. And you really don't want to start to discriminate based on payer source because we love our patients, we know our neighbors, we know our friends, and if some friend of Jamie comes in from down the street and wants to be treated by her and she says, I can't see you because you have an insurance I don't take, or I don't want to deal with the administrative burden, even if that is a significant factor and our therapists are already working hard and treating patients and are so committed. To add more paperwork and administrative burden to their day and their schedule is just doesn't make a lot of sense. So thank you.
Yeah. So Dr. Everett, let me just maybe ask kind of a broad question. When these things, because this isn't the first time this has happened, right? I mean, you get different player and they say, here's how we're going to reimburse it. Do they normally reach out to the PT Association in advance and say, hey, we're thinking about kind of a broad change to our in-network plan, and ask for comments or thoughts from the association or from other groups before, kind of how in this case it went out to you, what, 2 days, 3 days before it went out to everybody? Is that standard, or is this kind of out of the norm for how these things work? And
Mr. Chairman, I do believe that the reason that is not normal. The reason why it was done is, I believe, and I could be wrong, as you read up, you find out things, that this was one of those court mandated cases that Ash and the chiropractic group went at each other. And then they, through litigation, and Ash can correct me, I'm sure, that they had to notify the associations of the changes. So.
other representative Ward, go ahead.
Thank you, Mr. Chairman. This is a question for the team. Have you considered a type of concierge care? Now, if you're, sounds like you might be familiar with that. That's, you have a patient base and they pay you a membership fee. And if they should need your services, then they either, the membership fee covers it or they pay a little bit. So what I'm getting at is get away from insurance provider and provide directly to the patient. By doing that, we can increase competition, and then it may be insurance providers will start paying what's appropriate. So have you considered that?
Any of you have?
Thank you, Representative. We have, and you actually see that nationwide where you do have similar, not probably like the concierge services, maybe some of those do exist, but you are seeing direct to employer, because interventions early on can reduce those downstream costs for employees. So it does save them money from that standpoint. We do have obviously direct access, and people can come and seek our services. And we do have, ways that people can pay that make it affordable for them so that they can get the care that they desperately need. I know sometimes we talk about numbers, but the reality is that we treat a lot of people for free because we care about our neighbors. And so we figure out solutions to their problems. We don't have that same negotiation with others. Thanks.
Okay, yeah, Doctor.
Mr. Chairman, Representative Ward, yes, it is becoming more popular. The problem is when you have the patient that has high premiums for their insurance and they want to get physical therapy because they've had an injury and they can't do what they want to do, it's hard to get those out-of-pocket costs from them. And I have a very discounted rate for that because I don't have to go through all the administrative burden. I don't have to have a billing agency. I don't have to have a front desk. So I can deliver my care directly to them. So, but you get that patient with the high premiums already. That's where the problem is. Yeah.
Senator Hutchins.
Mr. Chair, to the group, I want you to know that we're hearing you. One of the things I've noticed since being on this committee, we started with a pharmacist. Now we're at the doctors. Now, today we're hearing about the physical therapist. It seems like this is a trend with our insurance company creating contracts you will sign before, or you don't know what's in the contract. And to me, that's troubling that this is happening. So pay attention to what the committee's doing. And as you see us working with the pharmacists, with the doctors, if you guys need us, do come to us for legislation, because this is like growing tentacles. It's crazy what I'm seeing happening. And the innocence, excuse me, on the insurance side, they say that, oh, we're innocent, but something's going on. And it's happening at the national level. And I believe you have a group of people here that would want to help you. So just pay attention to what we're doing with the others, and hopefully we can help you as well.
Other questions, committee, Representative Ward.
Thank you, Mr. Chairman. So one of the asks I see in your letter is that we move away from Cigna. And my question to our team here, my fellow legislators, is that possible?
Is it possible? I mean, we, just like every other payer, right? The state negotiates contracts and we, discuss with both sides. I don't want to speak for EGI or the executive branch, but, I mean, I think there are a lot of concerns and the feelers are out there, right? That when it comes time to renegotiate, nobody likes being pushed around. That being said, right, everybody's aware Wyoming doesn't have a whole lot of insurance choices, right? We have 2 or 3 or 5 maybe, and we've tried many things in this committee and the legislature for decades. Every time I have a candidate say, well, we could just do insurance across state lines. We've had that since 2009 and no one is taking us because we don't have an urban center, right? And just cost of care here is prohibitively high, as you're all aware. So yes, I mean, I think this committee, if we wanted to write a letter or discuss with the executive branch a bit more when it comes to renewing the contract, there are other players in the market. I think this will be in the discussion, certainly, as I'm looking at the governor's office and the Department of Insurance, but I don't think we're at the point where we're just going to go say bye Cigna. But we do, I think they have heard our concerns, and I think they have heard specifically from many of the providers throughout Wyoming that this might not have been the best way to roll this out. And we'll certainly ask Cigna here in a second, just to make sure they're getting the message. And it does sound like they are cooperatively trying to reach out, and so is Mr. White with individual basis and having some meetings. And sometimes these negotiations and contracts are messy, right? As a hospital employee, when they negotiate with their insurance, it's a messy, mean process. You see this with cable TV a lot. I don't know if you guys get those. Call this person and tell them not to delete this channel. So it's a messy environment, right, for everybody. But I think they've gotten the message. With that, any other public comment on this issue?
Hold on, I have a
Oh,
question.
Representative Trujillo, go ahead.
Thank you, Mr. Chair. I have a question for Cigna. If these physical therapists in Wyoming decide not to go and sign the contract with ASH or whatever your insurance is, what's going to be the cost once they go out of network to the patient? Right now, we're discussing doctor and insurance, but I haven't heard anything about the people that are receiving the services. We're going to be in I could be in physical therapy for 6 months. This goes into effect in July. Now you're causing an undue burden to myself. So what would be the cost of sending me to as an outpatient person?
And
Yeah,
Cigna, you can
so-
certainly try to answer it. I think it's specific, but Mr. Durenzio, go ahead.
Yeah, I'd much rather answer it this way. The gentleman that presented initially said something very important in that we're not looking for a legislative solution to this. Here you have, on Cigna's behalf, a very willing partner to work through your concerns. You've raised several that are, very poignant, important for us to resolve. I see no reason. I haven't heard any showstoppers in this conversation. So before we jump to canceling our contract or taking drastic measures, I'd much prefer we had a dialogue and work through these issues. I mean, if anything, our presentation today should be clear in this manner. We hear you, as you've said, Chairman, we hear you loud and clear. We want to work through those issues. I would ask Mr. White to respond to some of the anecdotal comments because we want to make sure, the record is clear on that. But I think we have a lot of ground to cover, and we could certainly do that. And I look forward to that engagement if that's the intent of the provider community in this legislative body. Thank you.
Yes, thank you.
Oh, go ahead, Mr. White. Yep.
No, I'm just responding to the request from Mr. Durenzio to supplement the comments. A couple of things. One, let us be clear that we share that commitment. We are engaged in listening and are being responsive to the feedback that we are getting, and understand that these are issues that we need to address. I want to clarify a few things. Number one is the July 15th date was the date for submission of an application following review of the contract. So the contract has been provided. the proposed reimbursement has been provided. That results in dialogue associated with the feedback that we are hearing around what specific reimbursement levels are by providers specific to their circumstances, because reimbursement does vary. And that's in every market. The second is that the effective date of the program is September 1st as planned. So there is time. The time in order to have the application submitted is in response to the feedback regarding credentialing, and also to provide transition without member or patient disruption. With respect to the timing of the association meeting, it is not a requirement of anything that we have been involved with legally or otherwise. It has always been our practice for 30 years to engage in state associations on the introduction of new programs. We have educational sessions with them. We describe what it is that the process is in terms of the network transition or development. The request for this meeting actually was from the APTA national leadership in order to support a single meeting with all of the states involved. And so that has resulted in some of the timing challenges that have been expressed to you. I will pause there, but again, I am confident again in support of Joe DiRienzo's comments around our commitment to understand and work through and address the concerns that have been expressed, and hopefully resolve some of the information that we believe just with education will clarify and resolve some of the concerns that have been presented as well.
And Senator Barlow, did you have a comment or question? You're good. Representative Hornock, you have something still?
Thank you, Mr. Chairman. A couple of questions for Cigna. I was looking for your slide through your slide presentation, and it must have just been a comment that somebody made. I'd like to know what percentage of your market share is Wyoming versus what you have nationally? And then are you changing the contracts in the same way just in Wyoming, or is it across the board within other states? Could you answer where you're or let us know where you're going with this generally?
Sure. Mr. DiRienzo, if you want that one.
Yeah, thank you, Representative Hornock. As I said earlier, we're already in 25 states nationally, and this would be an expansion to conclude that national footprint for the management of these services. So I don't have the data with me regarding your request for a percentage of Wyoming, but we could certainly pull that and make it available to this committee post this conversation. And then your other question about, is this different for Wyoming than anywhere else? No, we follow the same exact contractual arrangement and approach in all of the other markets that we've rolled out into nationally.
But no follow-up, Representative Hornock? Go ahead.
Yeah, thank you, Mr. Chairman. So are you getting the same pushback from any of those other locations that you're getting, that you're seeing in Wyoming? And just with that, please answer that question. With that being said, also something that oftentimes happens in Wyoming, if we're one of 25 states, generally that's half of America. Wyoming is a drop in the bucket. Population wise, oftentimes, on the financial side of anybody's national ledger, Wyoming is a drop in the bucket. So, this is a concern of the people here in Wyoming and the providers here in the Wyoming and health care here in Wyoming. What's going to be done about it other than we hear you type of thing? So are you getting pushback from other places? And then that's a comment that I have for this as well.
Go ahead, Mr. DiRienzo.
Yeah, thank you, Representative. While we've not heard this kind of pushback in the current term, it is not unprecedented, and we've been able to work through these types of issues historically. As I said before, you have a willing partner to do that. If you need a proposal on timing, on how we resolve this, I'm happy to consider that, bring it back to my organization for consideration and response. As I said, we want to provide you and the provider community with all options that we could work through this. We've seen it before. It's not unprecedented, and we could do it again here. It just makes sense for us to be flexible in this manner, because as I said, we want a broad geo access for our customers, and certainly want to be able to meet all of the expectations that our clients have for us with regard to the appropriateness of care, appropriate cost and affordability and all of that, as we, for the reason why we enable such networks. So there's a balance that we have to accomplish, but we certainly are willing to, stretch, be flexible as much as we can to ensure that we have that availability in the state of Wyoming.
All right, Representative Claston.
Thank you, Mr. Chairman. Thank you, Mr. DeRizo, and to your team for being here today. I think the state of Wyoming and Cigna in the past has had a good relationship. Unfortunately, the way this rolled out, it's kind of given Cigna a black eye. So I think that's something we need to work on. I want to share a question that I received from my constituents and just asking, how can Cigna or ASH ask us to deliver PT care at less than our cost of delivery? And then you see Cigna with profits of over $6 billion last year. So it's, in a conservative state like Wyoming, that it's a hard thing to justify with our constituents, just on the surface of what people are seeing.
Any response to that, Mr. Durenzio?
Well, I can't speak for, Cigna's profitability and the rest. We're not asking for providers to offer services less than they can afford to deliver it. So just to be clear on that. So that's why I think we need to figure out a way to resolve these issues that makes sense for both of us. I mean, that's as much as we could ever ask in building a network like this.
True. I guess the question then is, do you go into a state and do some research and talk to providers and get to really understand, what this kind of effect would have on their profit margin or their bottom line? And is it cooperative? From what I've heard, at least from my providers and what you've heard today, is many of them are saying the reimbursements are less than they can afford. They either currently charge or, it's just not cost effective. And I'm sure you'll hear that when they either do or don't agree to your contracts. But is there any upfront work either between you or ASH on kind of getting an understanding of the environment before this change got rolled out?
Yeah, while I can't speak to the individual contracted rates, that is, privy to ASH. I'll let Mr. White respond to how rates are developed. But certainly, the negotiation is the place to have that conversation, to absorb the rationale, and to be able to respond. At this point, while we've had the rationale, we haven't had an opportunity to really work out those details, and that's really what we're asking to do at this point. Bob, do you want to respond additionally?
Mr. White, anything?
Yes, Mr. Chairman. Just to add to that, I think that, clearly across the country, we have, again, successfully negotiated agreements with more than 50,000 physical therapy and occupational therapy provider groups and practitioners. And so that would not come about without listening and without responding to feedback and questions and clarification and education. That's why we have both telephonic as well as we will have field recruiters in the Wyoming market to support meetings and to directly address concerns on a provider specific level, because that's every provider has even across any market, different levels of reimbursement that they've negotiated for many factors. So our commitment is to listen, as Mr. Duranzo pointed out, and to respond and to successfully support this program with the support of those providers that Cigna contracts with today.
Right. Senator Hutchins, go ahead.
Thank you, Mr. Chair. This is to Cigna. My question is, it appears that you're willing to negotiate with our physical therapists and occupational therapists here in Wyoming. Is that a practice that you have from state to state? giving each person or each group a different kind of contract or deal?
Mr. Lorenzo?
Yeah, thank you,
The
Senator
per
Hudson, for
state?
your question. Yeah, thank you for your question. What we tried to do in general is work with ASH to come up with reimbursements in markets for whatever, rationale is devised, looking at local markets, looking at national databases, whatever, we work through to understand costs in those regions, et cetera, come up with something that is reasonable, that we think the provider community, could accept, et cetera. Again, we don't negotiate those rates, ASH does, but it is not uncommon for different groups to negotiate different rates. I think that's just a very clear result of negotiation. Bob, do you want to answer that as well?
Yes, I would reinforce that. I think that is true for any clinical aspect of our healthcare delivery system. There's not a uniform reimbursement process across all practitioners or providers for any medical discipline, including the providers that we negotiate with. And there are factors that are listened to and responded to in terms of, accessibility of providers, rural access, the treatment of pediatric cases, complex cases, the concentration of patients with respect to the particular provider groups, and obviously the importance of that to avoid patient disruption wherever possible, or abrasion with the provider community. So all of that, there's no one set fee. It is a place to start a dialogue and then respond to the feedback around the specific information we receive, and the flexibility is provided there to support negotiations to reach agreement.
Senator Doxer, do you have a question?
Thank you, gentlemen. What I hear you say, thank you, Mr. Chairman. Gentlemen, what I hear you say, you're willing to talk. I hear the words flexibility, possibilities. Let's go ahead and set a date and all come together around the table. Who do you want at that table from your side? Who do you want from our side? We're not going to legislate this. We're going to come and talk to you. Or you can come out here. Wyoming's a nice state. Don't want you telling a lot of people about it, but it's a beautiful place. Come out and let's see if we can get something worked out.
And I think after this deadline, maybe we'll check in with Jamie and Brent and a couple of the other players and see where everybody is, maybe a month before our Saratoga meeting. And not that I want to keep this on the agenda, and because there's not a whole lot statutorily we can do. But I think we all have a shared interest, because our constituents keep asking us about this, to make sure something's moving forward that everybody can work with and live with. And so perhaps we'll check, see where we are about a month out, which will give you a month after the date to see how many people agreed and how many are not happy. And if we need to have a friendly invite to Saratoga, Wyoming, which is lovely, to have some of you come out and let us beat up on you in person, we'd like to see that happen. So I don't want to delay anybody else today. I know you all have lunch plans and meetings, so unless there's any further things, Representative Trujillo, go ahead.
Thank you, Mr. Chair. I just have a comment. In discussing all this, I keep hearing the insurance companies say that they're not, the reimbursement to the physical therapist, doctor, pharmacist, or whatever have you. The client at the end of the day is going to foot that bill. That is the state for their premiums and the people of the community. So when we're sitting here and we're discussing this, we need to pay attention and probably get rid of the insurance company that we have and open the marketplace to bring in more insurance companies, so we can at least have a decent choice, because right now this is not a decent choice.
No, I think we all agree in other more competitive markets, maybe the tactics and the rates are different. When Wyoming, when we have 2 or 3 insurers, it's really painful. I think you've gotten the message today. We hear from people and they're saying this isn't workable. So I think everybody's committed to keep talking and working together, and we'll check in here in a month and kind of see where we are. And if we need to have a more, significant talk with other powers that be, as I'm looking around the room, we will certainly do that. Senator Baldwin, thoughts?
Thank you, Mr. Co-Chair. Just a quick comment here, and that is that I know at least one person is listening from the executive branch. I saw her shake her head. I think it's important that they're here at the table when we meet in Saratoga as well. And that perhaps they can get some more ideas from the executive branch and how to look at this.
All right, with that, no one else has anything else. We'll recess for lunch, be back here at let's say 1:50. And if the people on the agenda for this afternoon want to talk amongst themselves, so we could be a little more efficient because we have to be out here by 3, that would be great. Mr. White, Ms. Beard, Ms. Reynolds, Mr. Dorenzo, thank you for waiting around on us for about an hour today until we caught up to the agenda and spending some time with us. And we wish you the best and would encourage you to continue to work with our Wyoming people and try to find a way forward that isn't catastrophic and doesn't have people from all over the state of Wyoming emailing their legislators up in arms. So please help us.
Thank you.
Thank you.
Thank you for your time. Thank you.